The testamentary suit of 2017, Miller. On behalf of the plaintiff petitioner, I have filed my client's affidavit documents long back. The defendant is not filing the same. I have given notice that I will mention the matter
Testamentary
today.
suit. Testamentary suit.
Testamentary suit.
Now testamentary suit, my determination is not there. Check the determination.
May I kindly leave to mention a matter, my lord, upon notice, my lord, this matter was fixed on Friday at 3 p.m. Your lordship had risen on that day, my lord, because your lordship had a division bench. My lord, I'm mentioning upon notice, this matter is appearing as item number 9 today, my lord, but it has to be, my lord, refixed on some date, my lord, because evidence
What is
was
the
supposed.
stage?
Well, evidence was supposed to take place, my lord.
Item serial number 9.
9 of, my lord, the non-commercial list, my lord.
Yes, 211.
Yes, my lord. Yes, my lord. Yes, my lord. That was fixed on Friday, last Friday, my lord, at 3 p.m.
So it is
Yes,
for
so any date, my
witness
lord.
action of plaintiff.
I'm for the plaintiff, my lord.
The witness
Witness
action
action of the plaintiff, my lord.
plaintiff.
Issues has not yet been framed. It can be framed. What I may suggest to
Issues
your
not
lordship,
framed.
not yet framed. What I was suggesting your lordship, if your lordship can keep it after 15-20, as your lordship's diary permits, for 15 minutes, as your lordship keeps at 1 p.m., we can frame the issue on that day. And my lord, it can be refixed.
Why it is fixed for witness action without issue?
There
in order.
Your lordship's order only. So it can be refixed at 1 p.m. at any day, my lord, convenient to your lordship's diary. Sometime in.
Who is for the other side?
I'm mentioning upon notice, my lord. This Labaneshri Sinha is appearing. She's advocate on record.
Tenant company.
No, she was with Victor Moses at one point of time, but now I think she's independent. And Mr. Kuldeep Mollik, I think, is appearing as our counsel. It's that matter, my lord, in which, my lord, a section Order 7 Rule 11 was taken out for NCLT having jurisdiction. Your lordship had dismissed their application. From that, an appeal was made. The appeal, my lord, was also dismissed. Any day at 1 p.m., my lord, if it comments to your lordship.
For issues.
For issues, anytime, my lord.
14 March. But other side is not there.
I'll, my lord, inform. I'll inform, my lord. If your lordship passes an order, I will inform.
Record order. Item number 9. So suffering for the plaintiff. The matter was listed on
Friday, my lord. My lord, this is the order, my lord.
23rd February 2024 at 3 p.m. But the matter could not be taken up for hearing on the said date. Police, the counsel for the plaintiff submitted, though the case is fixed for witness action, but issues has not been framed. In view of the submission made by the counsel for the plaintiff, let the matter appear on 13th March, 14th March at 1 p.m. for framing of issues.
On that day, my lord, a subsequent date may be fixed, my lord.
Counsel for the plaintiff is directed to inform the next date of hearing to the learned counsel for the
I will, my lord.
Suggested issues exchange.
Not yet. Mine is ready, my lord. We may exchange in the meantime.
Directed to exchange the suggested issues in the meantime.
Deeply
Your lordship, may I be permitted to mention one matter, your lordship? Your lordship, in this matter, section 15 application was under the Commercial Courts Act was preferred by us being the plaintiff, and by order dated 9 January 2024, your lordship had allowed the suit to be transferred to the commercial division, your lordship. Your lordship, the affidavits have been affirmed. Your lordship, have a week's time could be given to file the affidavits, your lordship.
File the affidavits.
So, your lordship, I have with me.
But the matter is listed.
Your lordship, I'm mentioning the other side could not be notified, your lordship. So, if it comes as to be mentioned tomorrow, we'll duly notify.
Tomorrow has to be mentioned.
We'll duly notify the other side, your lordship.
Yes, call the matter.
Gratefully, lordship.
May I kindly mention, lordship? Urgent matter, lordship.
Yes.
Kindly, lordship, kindly. Thank you. Lordship, sorry. Lordship, kindly, for application. একটু দয়া করে লর্ডশিপকে দেবেন লর্ডশিপ কাইন্ডলি ফর অ্যাপ্লিকেশন লর্ডশিপ 3 my grandfather tax property and 1 TS1 2012 I went department told
Madam,
yes
now my determination is not there. This is a testamentary suit. The determination is changed. You go to the other court, check the list who is having the determination.
lordship where yes Yes, Lordship.
Yes.
Good morning.
Yes, Mr. Banerjee.
Your Lordship, kindly come to the evidence of DW. Only the 11 part pilot I may place before your Lordship.
DW1.
DW. DW1.
Yes.
Try to DW. Have to name. Possibly will not have. Yes, only DW. Only DW.
Yes.
Lordship, kindly come to question number 234. Lord, may I place before your Lordship, before referring the evidence part,
Yes.
why I am referring the relevant part, I am telling your Lordship's impression was gained by them that as if this property, 14 katas and odd, has been encumbered. Lord, that was the first day your Lordship put me that question to me.
Yes.
Only for this purpose, the relevant evidence. Finally come to question number 233. Yes. Kindly have a look at Exhibit D. My Lord, Exhibit D is the release date. 21 Lord 11 2012 release date. Release of the mortgage. Kindly have a look at Exhibit D once again. Do you find that you have represented that the property of the defendant number 1 was full of different tenants from whom the defendant number 2 used to collect monthly rent? Attention of the witness drawn to the last 2 lines of page 2 of Exhibit D. Yes. Who are the different tenants at the point of time? They are very one. Preeti Motor Udyog Private Limited, Aradhana Distributors, KNR Automobiles. Lord, then your Lordship kindly come to 249. Are you aware? 249.
Yes.
Are you aware? Hyundai has opened his showroom in the Howrah area? Yes. And will you agree that Hyundai Motors India Private Limited opened its showroom in the same building of the defendant number 2?
No.
No, actually it is extension counter.
Yes.
Then, Lordship, then kind 250. Yes, 250. Then your Lordship 251. Who is running in the extension counter in the property of the defendant number 2, Mohan Motors Private Limited.
Right.
Then 252 Melot. And this Mohan Motors Private Limited is also a dealer of Hyundai cars. Yes. Therefore, my Lord, during the period, Lord, defendant number 2, in which the property, lease property was released, that was encumbered. This property was not encumbered. Am I clear to your lordship?
No. Yes, yes. Again, you submit. Again, what is?
The property which is sought to be developed and which is sought to be transferred by way of a deed of sale, Lord, is the property 14.5.
Correct.
And further in terms of the MO, another 14.5, that is total 29 decimal is to be purchased.
Correct.
And over this total property, the development will be made. That was the terms of
the MOU.
Now, Lord, when the MOU was made, my Lord, at that time, this property in which, my Lord, the property was not purchased by the defendant number 1, he had no, my Lord, interest in respect of immovable property, but defendant number 2 is having interest in respect of that property. That is why lease was, mortgage deed was executed as a terms of security.
Correct. First mortgage.
That is first mortgage. Lord, that was terms as a security.
That was released.
That was released.
That was released.
That property was let out. That is defendant number 2's property.
So you mean to say the other dealer of the Hyundai, other person of the dealer of the Hyundai company has opened the showroom or extension, whatever it is, in the land of the defendant number 2.
In the land of the defendant number 2,
number 1.
not in the land of the defendant number 1. Defendant number 1 is the subject matter for the purpose of development of the property along with other intended property.
Because you have not given the property in terms of the MOU, that's what the Hyundai has cancelled and given to the other person. And other person has opened the extension showroom in the land of the defendant number 2.
No, because Lord, there was no contract in between defendant number 2 and the plaintiff.
There is no contract.
No
But
contract.
the plaintiff has made out a case as per the case of the plaintiff, because you have not carried out the terms of the MOU, you are not allowed you have not constructed and you have not given the land to, so that they are not able to establish the Hyundai company in the land of the defendant number 1. That's why the LOI given to the plaintiff was cancelled and the Mohan Motors have been given the
Lord, LOI, that was not the condition that this property will be given to them. Contract was the property in which was purchased.
Because of the LOI only they have entered into an agreement or MOU.
No. Because of the LOI, Lord, they have, because of the LOI, they have entered into agreement. No, that part I shall argue before your Lordship. Lordship, kindly skip over for the time being. Because that is also, Lord, the LOI as well as the contract, that is before entering into MOI.
Correct.
Before entering into
a MOI, because they have identified your property, you are identified
the property of what? Identified the property of 14.5.
Correct.
Not this property.
Not this. That's why there it also not the case that this is the property. Their case is that 14.
Right. Lord, what my submission before your Lordship is this. Your Lordship's impression is that this property has been encumbered.
Okay. Okay, continue.
This property was not encumbered.
Okay.
This was then. Because in any case, in terms of the MOU, Lord, he cannot, there was no contract in between the plaintiff and the defendant number 2 or for the purpose of taking any money in terms of the MOU. Lord, first is that there was no contract, privity of contract in between the plaintiff and the defendant number 2.
That you argue that.
No, there was no such contract.
Correct.
Therefore, and my property was released. My property was as a security given, because why security was given? Security was given because he had no property for the purpose of giving he means the defendant number 1 had no property to give the security, and therefore I requested defendant number 2 to give a security for that purpose. And soon after the property was purchased, that is on 21/11, 2012, on that itself, the property was purchased, deed was released, another my lord, that this property was mortgaged as a security. Lord, this cannot be denied. Lord, that is why we wanted to place before your lordship question number 252. And this Mohan Motors Private Limited is also a dealer of Hyundai cars. This is an extension counter. They are already dealer. Mohan Motors are already dealers.
Yes.
And you are fully aware that you are inducted a competitor of the, after frustrating the contract of the plaintiff with the defendant number 1, I disagree. When then your lordship kindly come to question number 254. When did you induct Mohan Motors Private Limited in the property of the defendant number 2? Somewhere in 2013 end.
2013.
End. Now, Lord, contract is up to, in terms of the dealership agreement, that LOI till March 2013. March 2013.
34 months, sir.
34, 30.
That's
first
why.
March.
That is the case they have made out, because you have not handed over the property to them. That's why they are not able to improve or
No, 31st March 2013.
Correct.
The last date for the purpose of giving.
Correct.
This. Now, Lord, that was given induct Mohan Motors. When Mohan Motors are inducted, sometime end of 2013.
Last
After the cancellation.
Correct.
What I'm
naturally, unless and until that LOI is not cancelled, how it can be given in the one place of the two dealer? Naturally, their LOI is cancelled because they are not fulfilled the condition of the Hyundai Motors. So that's why they went to the Mohan Motors, and Mohan Motors obtained this.
exactly. Lordship understood it. Yes, now, Lord, your Lordship, then kindly come to Lord page 250, question number 256. You have already deposed that prior to the agreement with the plaintiff, you are fully aware that the showroom was required by Hyundai cars. Am I correct? Yes. Then your Lordship kindly come to 259. I am suggesting it to you that you yourself facilitated the competitor of the plaintiff to open this showroom in the same area, where after getting the property released from the plaintiff.
Yeah, this is the case they have made out.
Lord, this case cannot, because that was given only in the end of that case cannot be.
Okay.
Under no circumstances that case cannot be. Yes, case was made out, but that case
where they have made out.
Yes, but
That's
that
why
case.
That's why they asked for the.
But that case was not in the pleading.
That's why they asked for that's why they asked for the compensation, because of the cancellation of the LOI.
Ask for compensation for breach of the contract in terms of section 68 also.
68 also, and with regard to the cancellation of LOI, because if they could have been open
the cancellation of LOI,
open the Hyundai Motors dealership,
yes,
they get the flourish business.
Now, my Lord, we shall satisfy your Lordship the reasons for cancellation of dealership, not for this, but for other reasons.
Okay, then that is
I will.
different.
Yes, that is their case. What your Lordship is opining during the course of argument, that is their case made out. Absolutely. But our case is, no, that was not the ground for which we are to argue on that.
Okay, they are arguing.
Yes. Lord, now your Lordship 259. I have further suggesting it to you that you yourself facilitated the competitor of the plaintiff to open the showroom in the same area, where after getting the property released from the plaintiff in respect of defendant number 2, I disagree. They approached me and the portion of the area was vacant. Lord, then 260. Since when was the property of the defendant when Mohan Motors had made the extension of the for light vehicle for more than 3 to 5 months? For more than 3 to 5 months. That is, below towards the end of Lord, 2013.
13.
When, my Lord, in May,
But kindly come to the 261.
yes, when in May, Lord, that was cancelled by Hyundai. Lord, this has happened long after the cancellation. Long after the cancellation, not before that. Before that, nothing was given. Kindly, Exhibit D, 261, look to the schedule so and so, that is deed of release. Will you agree with this same property where Mohan Motors Private Limited has subsequently opened their extension counter? Yes. That is why we say, before your lordship, that this property was not encumbered. The property which was encumbered is the property of the defendant number 2, which was the subject matter of release, that is Exhibit D. This is clear from the record itself.
Okay.
There cannot be any confusion
Okay.
from the evidence on record. That is why I am drawing your lordship kind attention. Lord, my impression was that as if my property was, Lord, sought to be, encumbered. That has been encumbered. No, that was not encumbered. And then, my Lord, your lordship kindly come to 262. On 21st November 2012, who was occupying the area, that area which was subsequently taken by Mohan Motors, it was occupied by Dev Auto Sales. After Dev Auto Sales, then Mohan Motors. Extension counter, Mohan Motors.
So if it is before the Mohan Motors, if the Dev Auto Sales was in occupation, how you are encumbered by entering into the mortgage deed before the first mortgage deed MOU with the
Lord, that is permitted, my Lord, mortgage, and this is the entire property that was mortgaged.
Okay.
For as a security. Lord, that is permissible. Even a mortgage property can be sold subject to mortgage. They have agreed. It is not neither of the parties. May I answer to?
But this fact was not in the MOU. But this fact was not in the MOU entered, the first MOU entered between the plaintiff and the defendant number 1. The Dev Auto Sales was in possession of the property.
Yes, my Lord.
Yes,
MOU, my Lord.
kindly see the MOU, first
Yes.
MOU.
Yes.
এই কোশ্চেনটা এমইউতে আসবেই না, তার কারণ এটা হচ্ছে সেকেন্ড মর্টগেজের জমিটা, সেকেন্ড মর্টগেজের জমিতে লেখাই হচ্ছে দিস ওয়াজ এনকাম্বার্ড বাই টেনেন্টস, ওয়ান অফ দ্য টেনেন্টস ওয়াজ দেব অটো সেলস।
না, তুমি কি বলতে চাইছো?
আমি বলছি স্যার এমইউতে এই যে দেব অটো সেলস ছিল কি ছিল না সেকেন্ড ডিফেন্ডেন্টের জমিতে, সেটা প্রশ্নটাই আসবে না, কারণ সেকেন্ড ডিফেন্ডেন্টের জমি আসে ডিড অফ ফার্স্ট
না, সেকেন্ড মর্টগেজ হয়েছে, সেটাতে হয়েছে।
ফার্স্ট মর্টগেজের জমিটা স্যার, এটা
হ্যাঁ, ফার্স্ট মর্টগেজ।
ফার্স্ট মর্টগেজের জমি আসলে স্যার ওই ফার্স্ট ডিড অফ মর্টগেজের প্রথম আসে
That is with regard to this
হ্যাঁ,
property.
সেখানে বলা আছে টেনেন্টেড, দেব অটো সেলস ওয়াজ ওয়ান অফ দ্য টেনেন্টস।
Yes, my Lord. May I read that, my Lord? দাও, ওটা এটাই আমাকে দিয়ে দাও তো। ওটা কেউ
মর্টগেজটা
পেপার বুকটা, পেপার বুকটা। Lordship, kindly come to Mo.
কিন্তু থাকবে না স্যার, কারণ যে অটো সেল ছিল হচ্ছে ডিফেন্ডার নাম্বার 2 এর প্রপার্টিতে টেনেন্ট, এটা বলা আছে যে ওখানে প্রচুর
Lord, tenanted. It is said, it is tenanted. Your Lordship, kindly come to. Yes, in consideration of the agreed term between the parties.
Which
Lord, running page 3.
exhibit?
Lord, this is exhibit B.
Exhibit B, yes.
Lord, Mo is in respect of the Lord the property which is sought to be purchased in part. Lord, this is the conditions with regard to how the property is to be given.
Yeah, that is the condition. There are several conditions.
That is the conditions.
Correct.
That has nothing to do with the property which was leased out, which was, my lord, not leased out, which was, Lord, mortgaged. That is the first mortgage. The first mortgage says that.
Yes.
Lord, how the terms and conditions of the lease and how the terms and
Okay,
what
you
are the
proceed.
terms and conditions of the sale of the property. That was the move. And Lord,
It was in the second
দাঁড়াও না, the execution and registration of the mortgage, first mortgage deed, Lord, which was released. Your Lordship kindly look to that document. Termination notice for commercial according to them 1 month. No, 1 month. 1 month taken off. Taken off. Lord, I may place before your Lordship. Before that, when we have come to the memorandum of understanding, one salient point is very much essential for the purpose of inviting your Lordship kind attention. দেখো কতদিনের 1 month দিয়েছে,
টাকা ফেরত দাও
15 days.
টাইম মেনশন দ্য মর্টগেজ ডিড, মর্টগেজ ডিডটা দেখাইছ না,
দাঁড়াও
15 days 15 days.
Lord, because your Lordship kindly look to that because they made out a case of termination of the move. They made out a case of termination of the move. Now your Lordship kindly look to paragraph 25 of the move, because your Lordship is looking to move 3 months notice. Termination 3 months notice.
Which exhibit?
Exhibit B.
Hmm. But this has been released. This deed has been released. So question of termination, how the termination will come? This has been released and subsequent.
No. Move has been terminated.
Yes.
Their case is move is terminated.
Correct.
Their case is move is terminated. Our case is move is existing.
Which move?
Your remedy,
Which first move?
first move, that one move. There was no two move, my lord, one move. Move relates to, my lord,
Correct.
letting out the premises and selling the property.
Correct.
Two parts. Move is having two parts.
Two parts.
Two parts. One is selling and another is, my lord, by giving lease.
Correct.
And lease rent was also given, and that was also, money was paid. Lord, that is 1 crore 25 lakhs.
Correct.
Now, Lord, I say before your Lordship, kindly look to 25, 3 months calendar prior notice. Internal page 9, Lord, paragraph 25.
Yes.
He said that it has been terminated. I say no, it is invalid.
Yes,
It
sir.
is still existing.
Exhibit.
Therefore, your right to enforce the specific performance of contract by realizing money is available. That is our case.
Yes.
That is our case, my lord. Lord, now your Lordship kindly come to Exhibit F. Exhibit F, my lord, is the, according to the plaintiff, termination notice.
Yes.
Lord, the date 11th September 2014.
Correct.
When it was cancelled, Lord, cancelled in May 2013.
Correct.
Cancelled in May 2013.
Correct.
Now, Lord,
They refer to the memorandum of understanding.
memorandum of understanding, they referred. Now, Lord, paragraph 1, your Lordship sees, reference is drawn to the above memorandum of understanding dated so and so, wherein you have assured for purchase of a land measuring 29 katas identified by Dag number so and so within PS Dongju district, Howrah, and we are liable to construct a building thereupon with the plan sanctioned by the local municipal authority, and out of the said construction you agreed to sell us 6,000 square feet carpet area in the ground and first floor of the building at the rate of 3,000 square feet in each floor for our showroom, and to grant us on lease 12,000 square feet covered area on the ground floor for our workshop. You have also executed and registered a deed of mortgage, mortgaging the property mentioned in the deed, and took loan of rupees 20 from ourselves. Lord, it is not the case in terms of the amount. Then you, on receipt of a loan by mortgaging the property mentioned in the deed of mortgage, have not only executed, registered a mortgage deed in favor of private limited company, but you have deposited the original title deeds of the property, which comprised in the schedule of the said deed belonging to the mortgagor Sabri Properties Private Limited, that is dependent number 1. Therefore, by deposit of title deed, equitable mortgage.
Correct.
Mortgage by deposit of title deeds. And the mortgage, nomenclature mortgage, it has been said as a security.
Intention there was also.
Then is Sabri Properties with the intention to create security thereon for repayment. With the intention to create security thereon for repayment of the sum of rupees atto with interest to the mortgage, so and so. Till now, you have purchased only 14.5 katas, and out of the above 29 katas with the account of loan taken from our company by mortgaging the property by deposit of title deeds, you have agreed to purchase for the purpose of execution of our contract under the above referred memorandum of understanding. It is to be noted that under the said memorandum of understanding, you agreed to complete all civil construction work by 15th of March 2013 and make it ready for commercial operation by us. That after the lapse of period of more than 18 months from the date of memorandum of understanding, you have neither purchased the rest of 14.5 katas of land nor made any construction on the said land, which is construed as complete default and negligence in performance on your part, and consequently adjustment or mortgage loan does not arise in failing on your part to raise construction on the property and hand over the property for the object. The memorandum of understanding and mortgage deed was executed and registered, and you are liable to indemnify the company for losses for breach of MOU and claims and demands whatsoever arising from loss of business, loss of profit, loss of interest, loss of employment, etc. as per clause 20 of the memorandum of understanding, that due to default in performance in terms of MOU, do hereby rescind, cancel, revoke the memorandum of understanding dated so and so, quote to it, and hereby cancelled. Lord, that is not permitted under clause 25, 3 months notice. Unilateral. Number 1. Number 2, that is contrary to the conditions. Number 1. Number 2, my lord, it is not a case whether termination is valid or invalid.
Yes.
Termination is valid or invalid. Secondly, my lord, it is not a case as to whether he is entitled to a specific performance of a contract for returning the money in terms of section 22 of the Specific Relief Act.
Correct.
And so far as the lease is concerned, that is also for the purpose of return of for failure on their part to perform the part of the contract. Whether they are agreeable or we are agreeable to perform the part of the contract, Lord, that is a question to be decided in that case. Now, whether they are willing to perform the part of the contract or not willing to perform the part of the contract, or there is a default on our part in view of the injunction order, that is a question that cannot be gone into in a simplicity or money suit.
Yes.
Now, Lord, your Lordship
that
kindly.
you already argued. With
No,
regard to
this
that
point I have not argued, my Lord, your Lordship kindly
that with
remember
regard
it.
to the point whether the specific performance
Yes, that
without the
part I have
performance,
already argued.
you already
No,
argued.
that part I
Not
have
to
already
repeat.
argued.
Please further forward you.
Only for the, yes. My Lord, now your Lordship kindly come to, Lord, the mortgage, the first mortgage which has been released. 12th of October, Lord, 2012. Lord, 4th of October 2012, my Lord, is the move.
Yes. Yes.
I have taken money. Now, my Lord, the property belonging to the dependent number 2
Was mortgage in the first MOU.
was mortgaged by the first mortgage.
First mortgage.
Mortgaged by the first mortgage. Now, Lord, first mortgage, your Lordship sees. An existing property, and whereas has been agreed by all the parties to the deed that advance amount of rupees so and so shall be given.
Where from you are reading?
Lord, page 5.
Yes.
Lord, page 6. Lord, page, Lordship kindly come to relevant at page 6. Lord, entirety I need not read, my Lord, only the relevant part.
Correct.
Page 6. That in consideration of sum of rupees so and so lent and advanced to the developer by mortgagee, the receipt whereof the developer does hereby, and also the receipt admit, acknowledge, confirm the said sign-copper mortgager does hereby grant, create mortgage on the property described hereunder without in the schedule without possession, unto in favor without possession, unto in favor of Fortis Export Private Limited mortgagee, and assure the same by security for the repayment or by means of other adjustment of the sum of rupees 2 crores together with interest thereon, out of 75 lakhs will carry interest 12%. Therefore, not in respect of the entire money.
Yes, that is
That I have argued. I need not further argue.
that you have brought on
Your
record.
Lordship wanted to know that whether the tenanted property
Finally come to the page 7, last paragraph.
page 7, that is I wanted to read that, my lord. And the deed further witnesses that the mortgagor and developer thus hereby assure the mortgagee that notwithstanding any act, deed or thing done, executed, performed hereinafter suffered to the contrary, the mortgagor has good title, definitely good title,
Yes.
Even today, the defendant number mortgager has good title in respect of this property. Good title till power and absolute authority to charge, assure, and mortgage the said property in the manner affected, and that the same is free from encumbrances, free from encumbrances. Lord, at that time, no preemption suit was filed. At the time when this was executed and registered, no preemption suit was filed. But because the property was purchased, then preemption suit was filed. After it has been registered in a volume.
Which property you purchased?
The property 14.5
From whom?
from Chatterjee.
Correct.
Chatterjee.
And this mortgage deed entered between whom?
This mortgage deed entered between with the defendant number 2 and the plaintiff.
So, with regard to this property, the mentioning of the property of which property in the mortgage?
Yes, my lord. Yes, Lord. Yes. No. ঠিকই বলছে তো। Yes, your lordship is right. I am correcting my argument. Yes. I am correcting my argument. I am grateful to your lordship. Lord, yes, this is, my lord, a property which is the subject matter of the first mortgage. Unencumbered property, not that is absolute. Yes, title, good title, free from encumbrance and attachment, and they shall be jointly and severally respond. Now, my lord, this has been released.
That released. I am not on
It has
that.
been released. Therefore, question not indemnifying loss doesn't arise.
But you have put the question in the cross-examination. That's why you have put the cross-examination. Who was in the property prior to mortgage, prior to taking away the Mohan Motors?
Lord, they
Bail out of the bus,
cross-examine.
whatever it is.
They cross-examine the witness.
Whatever it is.
I did not.
So
They
that-
cross-examine.
So that's why they have brought on
That is
record.
why, yes, they brought on record. They cross-examine the
Correct.
witnesses, but that is immaterial now. Because of the release, now on the basis of this, they cannot initiate an action after releasing. But my respectful submission, after releasing, they are not entitled. You may say that my property, you may claim for a specific purpose, or you may claim for enforcement of the security by way of redemption of the mortgage, by way of a foreclosure of sale, or by sale of the foreclosure or sale of a property. Decree for foreclosure or decree for sale of the property.
Okay.
Mortgagee is also entitled for realization of the amount for a decree for sale, not foreclosure, but decree for sale. And mortgager is entitled foreclosure, redemption by foreclosure.
That you argued.
Yes, that is the law.
Next.
That is the law.
Next.
Therefore, so far that part is concerning material. Lord, therefore, my respectful submission before your lordship is this, that only my submission is the property which was, Lord, released, that was tenanted. Subsequently, my lord, in the evidence it come, it now remain vacant. Lordship, kindly come to next page, 264.
Yes, I am there only.
No, 1.5 crores that have been, my lord, clarified in 284. That is a mistake.
That is the
1.5 lakhs.
1.5 lakhs, yes.
1.5 crores. This
That
has been clarified, my lord, in
monthly rent cannot be 1.5 crore. This is 1.5 lakhs.
Yes. Now, my lord, 284 and 86. Lordship, kindly come to 284 and 86. How much it is? Mohan Motors Private Limited, being the defendant number 2, approximately 1.50 plus GST also added. They have left the premises. Then, my lord, kindly come to 286. 285.
286 is
285.
the clarification.
Clarification. Yes. Then when did motor leave the premises? Since last 2 years only, with effect from February. Then 286. This is a clarification. 1.5 lakhs or 1.5 crores. It was 1.5 lakhs.
Yes.
Now, my lord, your lordship, this fact is admitted by PW1 in question number 116 and 118. With reference to the cross-examination answer, Lord, the answer in examination in chief of PW1, 116 and 118.
116 and 118.
And 118. Paragraph 21 of the plaint, your attention is drawn to the pleading where the plaintiff has stated that Hyundai Motors has cancelled the letter of intent and has given to someone else. Can you indicate what is this something else? Interestingly, when land went into jeopardy, the defendant number 1 did not offer any solution to the plaintiff. However, few months later, another company by Harshit Hyundai was given a property owned by defendant number 2 for the same purpose, that is to set up Hyundai dealership in Howrah. That the defendant number 2 has clearly colluded with the Harshit Hyundai and could have orally offered the same property when things went into legal tussle in the original land. Number, privity of contract for taking amount of rupee 2 crores in between the plaintiff and the defendant number 1, not with the defendant number 2. Defendant number 2 was involved because he stood as a security by giving the security of his property by way of execution and registration of a mortgage deed. Nothing more, nothing less. Lord, therefore, my lord, collusion or no collusion immaterial.
No, that is the case they have made.
But that case, they can make out every A to Z case. But whether that is permitted in the eye of law or not. If the question I put to myself, is there any contract in between defendant number 1 and the plaintiff and defendant number 2 and the plaintiff for the purpose of giving money? Who has taken money? A juristic entity under the Companies Act. Lord, that is defendant number 1. There was no juristic entity so far the defendant number 2 is concerned. His property was released. Now, how he can be entangled in this property? His case is that siphoning money. Lord, siphoning money case, Lord, I have already argued. I need not argue before your lordship. Now, Lord, your lordship, kindly look to the next line. Interestingly, when land went into jeopardy, the defendant number 1 did not offer any solution to the plaintiff. However, a few months later, another company by the name of Harshit Hyundai was given a property owned by defendant number 2 for the same purpose, that is to set up a Hyundai dealership in Howrah. Thus, the defendant number 2 has clearly colluded with Harshit Hyundai and could have orally offered the same property when things went into a legal tussle in the original land. Lord, that was not the offer between the parties. Why should I give to Harshit? They ought to have given offer to us. No such letter, no such correspondence. We ought to have given to them. Why? That instead of that, you take this. Because, my lord, he is a businessman. I am also a businessman. I want, my lord, I do not want any litigation. He also doesn't want any litigation. Businessman doesn't want that. Lord, we want to earn money from the property by keeping the property in idle. When my property has become idle because of the pending litigation of preemption, I ought to have given, I ought to have requested, because I am also a director of that company according to the evidence comes in. Dependent 2, dependent 3, dependent 4, dependent 5, partnership deed. It comes from the evidence itself. I ought to have. Is there any case made out by them that it was not, that is why it was not given to us? We ought to have given to them.
No, that
It is not a question of tussle. It is not a question that the competitor comes in. I shall enjoy the money. No, I wanted to develop the property. Certainly,
that's why once you came to know that
Lord, our unfortunate.
your land is in the went on litigation subsequent to enter into the MOU or agreement.
That's right.
And you have the defendant number 2 has taken release of his landed property. When you came to know about the litigation, and you, because it's a partner, defendant number 2 is also partner of the defendant number 1. Once the defendant number 1 came to know, or the defendant number is going to lease out given the property to other owner, other dealers of the same Hyundai company, why you have not given proposed for the plaintiff? Yes, it is a litigation, you come with this property.
Lord, even then he cannot, because there was no LOI in respect of that property. Hyundai will not give.
That is different thing.
No, that is, I am telling you, Lordship,
That
there
is
must
different
be a
thing.
lot.
Whether the Hyundai will, whether you have informed the party, yes, the defendant number 2 also wanted to sell it or the mortgage the property, you come and you take this
But that was not the proposal given by them.
Not
We
how
ought to
they
have
can.
given.
How
We ought
they
to
can.
have.
It
Lord,
is
we
you.
ought, that Lord, my submission is we ought to have given proposal. We have not given.
Correct. Because it is you.
Lord, why, what my submission is, my reply is, yes, we ought to have given this proposal. They ought to have given also proposal so that we can. Lord, both of us.
How they can know that the defendant number 2 is interested to sell the property? How they can know? You are the person, you know that yes, defendant number 2 is selling the property to the other Hyundai dealer. How they can know? It is your property. You are
No. Property was
the
vacated because Mohan Motors vacated. New persons came in
subsequently.
after 4-5 months.
Subsequently. Once,
Yes,
once you know during
it
the
was known to
during
them.
the validity of the LOI of the plaintiff, you came to know that your land went to the litigation. You got the other party got the order of status quo, whatever it may be, preemption suit, whatever it may be. And you also know because the defendant number 2 is your partner, and defendant number 2 is giving the said property to the third party, to the other dealer of the Hyundai company itself. So you could have been offered that.
Now we could have offered. It is not offered. It is not offered. No doubt about it. It was not. It could have offered, but it was not offered.
So that's why they have made a
it was not offered, Lord, by the defendant. No, it was not offered by defendant number 2. Lord, my respectful submission is that defendant number 2, if he did not offer, he cannot be at fault because he had no privity of contract.
I am not on the defendant number 2. I am not on the defendant number 2 with regard to you, whether because he is your partner.
During subsistence of the MOU কি করেছিল সেটা একবার দেখুন। সে অ্যাপ্রোচ করেছিল হুন্ডাইকে যে দেখো আমি এইটুকুর মধ্যে বানিয়ে দিচ্ছি, তাও রাজি হয়নি। 145-2040।
লর্ড ইফ ইউর লর্ডশিপ, দাঁড়াও, এটার উত্তরটা দিই আগে। ফটাফট করে অন্য জায়গায় ঢুকলে হবে না রে ভাই। জজের উত্তরটা দিতে হবে, জজকে স্যাটিসফাই করতে হবে। জজ যেটা চাইছে সেইটা বলতে হবে আগে। লর্ডশিপ, kindly Lord, do not listen between.
I am not listening to you.
Lord, what I am drawing your lordship kind attention, Lord, it may be a, Lord, question would be, my Lord, that they did not, that in the event when it was released, from release means what? Means you can do whatever you like with regard to your property.
Yes, freed. The land has been freed. That is
land has been freed. Now, my Lord, he had no privity of contract. Therefore, for which, my Lord, the defendant number 2 law is not vicarious liability with me. Defendant number 1. What is the law if I ought not to have? Is there any vicarious liability? Because he did not say the, therefore I am liable for that.
Not connected directly.
Not connected directly. Lord, this is a legal point.
Okay.
Not connected, you released it.
Okay.
It means I am free. Whatever I want to do, I am free.
Okay.
You ought to have contacted with him. that I skip over this, kindly take this property, kindly tell defendant number 1, so that you can, whenever the property will be released, you give me that.
Okay.
And I will also participate with that.
Okay. Next.
Now, Lord, your Lordship, then kindly come to Lord, question number 58 and 59, 61 and 62 of PW1. Lord, purpose for which amount was taken is admitted by the plaintiff. Purpose for which amount was taken 1.2 to 25 crores and 75
That is admitted.
crores. Admitted. That is admitted in terms of, my Lord, PW1 question number 58 and 59. And 61 and 62.
That document itself, document is exhibited, document itself speaks. Document itself speaks what for the amount for.
Right.
Schedule is
Document itself speaks, and the evidence also says that.
also says. And the plain
None
case
of the
is also-
parties, my Lord, deviated from the terms of the document. Deviated from the terms of the document. Terms of the document, they are admitted.
Correct.
None of the parties, my Lord, challenge the document.
Only with regard to the whether you have violated or not.
Whether we have violated or not, that is the question to be decided, and whether simplicity or money
And
suit is maintainable
That
in
is,
the
that
eye
is the
of
law
law or
point.
not,
That is the law point.
or
in your
whether
case.
that is the law point I will
Sorry.
argue later on, Lordship.
Later on, you have already argued. You know,
No, another point I will, not the point which we have argued, that judgment I will not
okay, okay,
place before your Lordship.
okay.
Other points of law I shall place before your Lordship. Now, Lord, your Lordship, kindly come to question number 79 and 82, because your Lordship, on the on the last day, your Lordship put me a question whether any deed of purchase so far this property is concerned is there. I have shown your Lordship this way, but that document was marked Exhibit 1, the sale deed. The purchase deed by the defendant number 1 in respect of this property is Exhibit 1.
Exhibit 1.
Exhibit 1, question number 79 and 82.
Another. What is the dependent document?
Exhibit 1 on admission. Lord, 1 crore. Property was purchased 1 crore.
Yes.
Therefore, my title in respect of that property is there. And my benefit, my Lord, is, Lord, till today, this property 14.5, Lord, is remaining. Till today. Lord, my advantage is, Lord, he has deposited only 50 lakhs plus 10% in accordance with Section 80. In view of the judgment of Barasat Hospital case, my Lord, Supreme Court, subsequently 2 other judgment of the Supreme Court, that preemption is not maintainable. Held that. We filed an application before the preemption court that the plaintiff is liable to be rejected on this ground alone. Lord, then they did not dismiss for default. Then they did not enter appearance for restoration of that.
When that suit was filed?
Yes, that suit was filed. That is within a period of 4 months.
After MOU.
After MOU. Lord, after the document is registered. Not
That's
after MOU. MOU was 4th of
Second mortgage.
second mortgage. That is 21/11. 21/11/2012. 2011 possibly, yes. 2000. হ্যাঁ হ্যাঁ
Yes.
আঠাশ ও 28/1/2013 because 21/11/2000 28/11/2012 21/11/2012 was the deed of sale. Then 11/12/1/2/3 within 2 months they have filed preemption case within a period of, and 50,000 they have 50 lakh they have deposited with that amount.
Okay.
Now, Lord, according to the interim order that was granted, that they wanted to have an interim order. Ultimately, the interim order was by the single judge, my Lord, said that the interim order with regard to the transferring and other things that cannot be granted in such a way, but the amount which was given, that is 60 lakhs, that they have, that we shall not be allowed to withdraw in the event the amount is, in the event the preemption application is allowed. Thereafter appeal was prepared, appeal modified that part. But so far that part is concerned, I am not, Lord, entitled to withdraw that amount. Question of withdrawing that amount doesn't arise at all. Now his right has been lost. Therefore my title is there. Even they can come and purchase the property, but they will not be agreeable. What can I do for that? I cannot force him to purchase the property. But my intention is very good, my Lord. It is not that, my Lord, purposefully, deliberately I wanted to harass them. No. Because I am a businessman, I wanted to earn from that property. Even today, my Lord, because how can I do it? Because development work has been made, 63 lakhs and odd amount was given, Lord, through the dependent number 2 to the 43 lakhs, and then balance amount was given directly to the dependent number 5 for the purpose of development of the property. And for development of the property, your Lordship kindly look to that, my evidence part. Lord, question number 197 of DW.
197.
No, 197.
না 177 এটা দেখাচ্ছে না এটা দেখাচ্ছে না তো? এই বছর শেষ হবে এটা দেখাচ্ছে লিস্টটা লাগবে
No, that is with regard to non-involving. Lord, we first of all, my Lord, may I draw your Lordship kind attention first. এটা হচ্ছে লোনের ব্যাপারে।
প্লাস স্যার 5 এর কাজের কন্ট্রাক্টটা ওইখানে
Page 100, Lord, question number 177. DW. If this statement in the written statement according to you correct, what was the involvement of defendant number 225 in the transaction? The defendant 1 has done the transaction with the plaintiff. During the transaction, the defendant 2 and 5 were involved. But regarding development, defendant 5 was given a contract with the company for development. In the transaction, defendant 2 was not involved. Lord, document also says that.
Yes.
Defendant 2 was not involved.
Then
ট্রানজাকশনসে ইনভলভমেন্ট টাকাটা তো ওখানে গেছে এটা বলছে তো আমার কাছেই থাকবে
Now, Lord, your Lordship, kindly come to 182. How much money did the dependent number 1 pay to the dependent number 5 for this alleged contract? 63 lakhs 90,000 and something. But the balance of the dependent number 1 is showing only an amount of rupees so and so, that I told earlier that balance amount may be repaid through dependent number 2 company. That is, I will have to check. Then, my lord, 184.
So what is the development made in the property?
Yes, that is I am telling your lordship. What is the development made in the property? Lordship, kindly come to. Lord, first of all, transferring the money. Lord, let me conclude this part, my lord.
Yes.
The dependent number 5 was involved in the development, 184. Then, my lord, $188. I am therefore suggesting to be money paid by the plaintiff has been siphoned by the defendant 1 to defendant 2 and thereafter to defendant 5. And if the corporate will is lifted in all 3 entities, but you and your wife will be bound to be present, I disagree. Then
187 টা পুরো দিন G2 তে ট্রান্সফার হলো টাকাটা ওটাই তো করলেন আসলে কতটা ছেড়ে দিল
187, my learned friend is insisting. You read 187. Very well. I read 187. 187. What was the requirement of the defendant number 2 in respect of money that was advanced by the plaintiff? There was no requirement of the defendant number 2. Money was transferred to the defendant number 1 company, after that to the defendant number 5. And that I will have to check it.
One নয়
Thereafter, I will have to check it. Dependent 2 company. Dependent 2 company. And that after that, dependent number 5. Dependent number 2 company. Lord, now your lordship kindly come to page 190. Is it your case that the amount of rupees so and so has been refunded to the defendant either by the defendant number 2 and defendant number 5? No, we had no refunded. It was invested. Then, my lord, your lordship.
Where? Which question?
Question number 190.
Yes. We are not refunded. So that's why there is no development.
No, not refund. Now, my lord, not refunded. That doesn't mean, my lord, that there no development.
There is no answer that now question of defunding does
No,
not arise.
refunding the amount and development has been made. Thereafter, it has been clarified. Lord, it has been clarified. That is why I wanted to place it before your lordship, that part.
Okay.
Lord, 190, 195. First of all, 194. Out of 29 katas, you purchased 1.5 portion, that is 14 katas and odd. Am I right? Yes. That is exhibit 1. Then the balance 50% of the land as on date remains unpurchased. Am I right? Yes. This is admitted fact. Therefore, the question of effecting construction also does not arise. Am I right? Technically, it does not arise because we could not get the plan. Then 197. Lord, from 197 onwards, Lord, the development portion. Since you could not get the plan, then on what basis did you make construction? A proposed plan was made, and according to the proposed plan, considering the laws and bylaws, the construction was initiated. Lord, then 199. I am suggesting to you that a story of proposed plan was made by you for the first time when you deposed before this honorable court. In your examination in chief, what do you say? I was made in the year 2012. It was handed over to the plaintiff for approval of the proposed plan. Then, my lord, 201. You have just admitted.
199 is to be read with 198. You have not taken the same stand in the written statement.
199 to be
read with 198.
198.
Because you have not taken that stand in the written statement which your witnesses deposed before the court.
Is it the story that the proposed plan reflected anywhere in the written statement? I have to check.
So whether the written statement you have made, take out that
My lord, my respectful submission, Hey, our witness statement দাও তো। Lord, so far the plan development is concerned, Lord, plan is concerned. Lord, this is the evidence part. This is not, Lord, required for in the pleading. This is the evidence part. How much development? Development we have made. We have said development has been made. Now, how the development has been made, to what extent the development has been made, that is evidence part.
Okay.
Evidence part, my Lord, need not be pleaded.
Okay.
Lord, now your Lordship kindly come to 201. You have just now admitted 50% of the plan remains unpurchased. So on what basis are you claiming ownership? 50% of the land was purchased and rest was proposed to be purchased. And considering that only proposed drawing was made and it was handed over to the plaintiff for approval from Hyundai Motors India Private Limited, which did not happen.
স্যার ডেভেলপমেন্ট হয়েছে প্লেন্ট কেসে প্লেন্টের পেজ 10
Lord, plain paragraph, they have admitted the development has been made. They have admitted in their plaint, development has been made. Paragraph, my Lord, 14 of the plaint. Lordship kindly come to paragraph 14 of the plaint. They have admitted. একটু থাকো ভাই, তাহলে আমি আর্গুমেন্টে তোমার পাবো না। হ্যাঁ। Notwithstanding the assurance of the defendant 1 to 4 that commercial construction shall be developed within 6 months.
Little progress of development.
Yeah, little progress.
That is the case because
Now,
little
Lord,
progress
my
of
respectful
development.
submission, Lord, little progress of development is a vague word. Little progress to what extent? Certainly little progress. Because the land was developed, it was low land, it was developed by piling earth.
So where is the reply to this paragraph 14 in your written statement? Little. So
Yes,
where
49,
is the
yes,
written
yes.
statement on that
Paragraph kindly come to. Paragraph as against paragraph 14. Lord, paragraph 26. It is stated that the development of the property has been made and development of page 25.
Yes.
It is stated, on the other hand, it is stated that the development of the property has been made and the development activities has been made for the purpose of developing the property so that in terms of memorandum of understanding, property agreed to be sold can be sold in favor of the plaintiff and property agreed to be leased out can be leased out to the plaintiff and progress of construction was carried on smoothly. Now, how much and to what extent, my Lord, this is clearly cited in the evidence, oral evidence.
Okay.
My Lord, obviously that is not required to be pleaded in the pleading. Lordship knows that. Lordship has vast experience with
I have no
regard to trial-
experience.
with regard to trial of the suit. They kindly come to, my Lord, question number 207. Question number 207. So one day, will you also agree with me? And you did not have any sanction because you till date not even owner of the property. There was no sanction, but we had started the construction on the balance 50. There was no sanction, but we had started the construction on the balance 50% of the land. Then to what extent? Lord, extent was also said with regard to termination notice. Lord, our case is that we did not receive the termination notice. Paragraph, my Lord, 209 and 211. Then, my Lord, 218 200 এই পিলারটা কনস্ট্রাকশন হয়েছে দেখে নাও না, ওই জায়গাটায় বলা রয়েছে, ওই জায়গাটায়।
What about you? What is the
219.
what is the answer to the 219?
It is single letter from any of the defendant to the plaintiff showing that the plaintiff did not proceed with the project.
Yes.
Is there any single letter from the defendant to the plaintiff showing that the plaintiff did not proceed? Lord, this is I have to check. Lord, this is admitted fact.
What? Not said.
Project, Lord, I develop is there,
No.
but little extent.
Defendant showing that the plaintiff did not proceed with the project.
Is there any single letter from any defendants to the plaintiff showing that the defendant did not proceed with the project?
Check.
Yes, no letter, but project could not be proceeded with because of the injunction order.
Where is the injunction order you informed to the plaintiff? Where is the communication informing the plaintiff this is injunction order? We cannot go further.
No, they have admitted it in their plaint. They have admitted in
That
their
is
plaint.
subsequently. Where is
Not
your
subsequently, my lord. Not subsequently. They have admitted in their plaint
where?
that because of the injunction it could not be.
Letter to focus again to him.
Even in the letter to show cause notice.
Where?
Letter to the show cause notice. Yes, that I will have to place before that. First of all, my lord, I may place before your lordship the plaint averment. Plaint averment, they admitted it.
Hyundai your letter ও দিচ্ছে শোকজের রিপ্লাই হয়েছে অর্ডার ডেটে ল্যাপ হচ্ছে আমাকে স্ট্যাটাস করে
Lord, you first of all, Lord, before looking into the plaint, lordship kindly look through annexure
এক্সিবিটে
exhibit M. Exhibit M, my lord.
Give the exhibit.
31st May 2013.
লেটার ফ্রম Hyundai in reply to
Letter from Hyundai to
Nitin Hemant Singh sir.
Lord to Fortis Exports India Private Limited. That with reference to a reply dated 6th of May 2013 sent in response to our so-called notice dated so and so, calling upon you to so-called that to why
That is with regard to the Hyundai and plaintiff. I am not on that. Where you have stated that you have informed the plaintiff due to the preemption suit, injunction order was there, so you cannot proceed with that.
They intimated in their reply that a status quo has been granted by the
They have but sir, Mr. Banerjee,
Lord, whether I have informed or they came to know immaterial when he came to know.
why? It is your case that due to the preemption you could not proceed with the matter. This is
Right.
the simple case defense you have made. Some law point is different thing.
Right.
Where is the document to show that you are informed and when do you have informed that?
No, did you that answer is not that, my lord, to that extent. The answer is that I have to check. I have to check. Answer is, my lord, with regard to that, my lord, I have to check. I have to check.
Check and come. Yes, continue.
Yes.
Now you proceed with this.
Lord, here your lordship kindly look upon perusal of the order of the court. They annex the copy of the order to the court. Upon perusal of the order of the court attached to a reply dated 6th of May 2013. Eta reply tao to annex ache
না এটাই
exhibit. We noted
is-
that the court.
Sir, on the very first day, your junior had argued from this letter only. When I have put some question, then he left the court and brought you to argue the matter.
Because he's afraid, your lordship.
That's why I know this letter.
Oh,
He
yes,
has
yes,
started
your
the
lordship.
argument from this
No,
letter
no,
only.
your lordship knows it. Because he afraid to your lordship. That is why he left the court.
Why afraid? I am.
Oh, so he should not. He
Why?
should not. Right. He should not. He is to face the judge. Honorable judge always. Whenever court putting a question, he is to answer that.
Because on this
It
question,
should not
what
be.
the question I have put to you now,
Yes.
similar question was put to him, though he has referred this. I am telling this is the reply of the plaintiff to the company. Where is your answer? Because you wanted to bring that record, that order on record.
Now, Lord, it is known to him because he intimated that a status quo order is there.
You mean to say they had the knowledge, that's why it is not necessary to intimate the plaintiff.
Intimate them.
Okay.
They had the knowledge.
Okay.
Now, Lord, how he could get back the knowledge immaterial?
Okay.
Because he had the knowledge, he intimated to the authority. He ought to have answered that. Instead, he left.
Yes. Next.
Lord, he is a junior lawyer. Your Lordship will have to, Lord, always. Lord,
I
he is to
accommodate all the
He is
juniors.
to learn from your Lordship.
I accommodate all juniors.
All juniors. Your Lordship accommodated all the juniors. Lord, now your Lordship kindly come to the plaintiff apartment. Plaintiff apartment they have admitted. I go, 12টা বাজতে গেল তো কখন বসবে?
Yes. Next.
Paragraph my lord Q. Paragraph my lord, not sub-paragraph Q. Paragraph my lord.
Of plaintiff.
Paragraph plain. Paragraph 17, Lord, sub-paragraph Q. এইটা দেখো ভাই, প্লেনটা দেখো, ওখানে দেখো না। Lord, paragraph 10, your Lordship kindly come to paragraph 10, because subsequently this was marked exhibit 1.
Yes.
The defendant number 1 purchased only 14.3.
Yeah, that is the document that you already shown. With regard to the purchase of the landed of 14 quotas, there is no dispute at all.
Lord, paragraph my Lord 15. In February 2013, plaintiff was informed by the defendant number 1. Lord, your Lordship answer is this. Lord, your Lordship, Lord, query. Lord, to answer, we have to answer that. We are not to fumble the answer of the court. Whatever question is put by the court, honorable court, my lord, we have to answer. We are bound to answer. Duty bound to answer.
Yes.
In a state of arguing, in a state of avoiding, either avoiding to your lordship's answer. No. Whatever in my view, my lord, I shall have to answer that. In February 2013, plaintiff was informed by the defendant number 1 that no development activities in the portion of the said property purchase could be carried on by reason of orders which have been passed in the legal proceeding in LR case number so and so purportedly under section 8 of the Land Reforms Act initiated by the owner of an adjoining property against the defendant number internally claiming purported rights of preemption in the said proceeding by an order dated so and so defendant number has been directed to maintain a status quo with regard to the nature and character of the portion of the said property purchased as well as with regard to the question of alienation of the same till the disposal of the case. Lord, then we preferred an appeal.
Yes.
Lord, then appeal court said that you are to develop the property, but you should not give any encumber the property to any, even by transfer, by creating tenancy because of the injunction order. Then they prepared a review 227 application. Lord, 227 application when Mr. Suksinath Mukherjee came, Lord, I was there, Lord, at that time, on behalf of the defendant number 1. Lord, he said, I withdraw it. I shall withdraw the application. Direct the court to decide the preemption application on merit. Lord, my intention is not to do it. My intention is to do it.
Okay.
Lord, I want that he will develop his business. Because unless he develops his business, Lord, I cannot earn money. How can I earn money from that property? Property is remained idle now. Lord, I am unfortunate. I could not give the service to him. I am not denying that.
But the purpose which they wanted to take
75 lakh they are entitled.
No, no,
But not by this way.
on that. If what purpose for purchase of the property has lost the interest. Purpose for purchase
of the purchase of the property may not be lost because, Lord, that case was not made out by them in their plate.
Yeah.
Lord, if I purchase the property, that will be an asset. And if he say that I am not willing to purchase the property, the agreement we cancel. They said agreement is cancelled, move is cancelled. Forthwith. Contract is 3 months. You cannot unilaterally cancel it. Therefore, in the eye of law, contract is subsisting. Even today, you can purchase it.
No, that is correct.
Even today, you can purchase the
Lord, all
property.
this, kindly have a look at answer to 195, 196. Entire argument my learned friend has made for last 1.5 hours.
That's I'm telling.
No, 195, 196. What is
Up
my
to
learned friend arguing?
PW1, up PW1.
Lord, my learned friend knows. very well.
DW1, DW1.
No, no. My learned
His
friend knows
witnesses
very well.
admitted he is not in a position to
Answer
perform and he is
195,
arguing for
96.
hours.
Yes. I will answer to your query. What would be the legal question on that? 195, 96.
Yes.
The balance 50% on the day remains unpurchased. Yes. 196. Therefore, question of effecting construction also does not arise. Am I right? Technically, it does not because we could not get the plan.
Correct.
Yes, continue.
Because of the injunction order. And Lord, he is saying that these are the 2 paragraphs should be looked into. No. Law is entire evidence is to be looked into. And what was the entire evidence on the basis of which the parties' case are, that is to be decided by the court, honorable court. Therefore, 1 paragraph or 2 paragraph in isolation cannot be looked into.
No, that is correct. But the cross-examination.
So, my submission is, my lord, the whole difficulty was because of the injunction order. That was the difficulty. Now, Lord, I am not saying that I did not receive money, 2 crores. This is not my case. I said that yes, 1.25 crores I received it on
Why you're not settling the matter?
on that.
Why you're not settling the
Let
matter?
it be placed before the High Court, my lord.
No, my lord, nothing. Let my
authority.
learned friend finish it.
No.
Enough is
The
enough.
law says that. Supreme
Enough
Court
is
said
enough.
that. It has to be placed before that. It
Okay.
has to be settled.
Okay, any further?
No settlement.
Any further?
No, today, my lord, your lordship kindly.
And further, how much time further? 1.5 hours I have given today.
But that 2 hours,
Huh?
because with regard to other part, I did not.
What is the other part?
Other part, my lord, damages part. Damages part is not maintainable. I shall argue before your lordship with reference to the
On
evidence.
the last occasion, you tell only you want 1.5 hours. I have given 1.5 hours. 10:30 to 12. 1.5 hours over. Now you are telling that
of his argument.
this is Mr. Banerjee,
No. I will not, my lord, make any argument which is immaterial one or which is not convincing to the judge. Whether judge will be convincing or judge will not be convincing, but after all, my lord, a convincing argument is to be made before your lordship. This is up to your lordship to consider my case.
that is there.
Lord, that is there, my lord. Lord, because I shall have to come back to that part, because two parts. First part is with regard to 2 crores, second part with regard to 300 crores.
That you argued.
No, that I have argued.
Yes.
Now with regard to that part, I shall have to argue
What compensation?
for compensation.
Hello. अनुतोष क्या कौन सा डेट पड़ेगा? दो डेट फर्स्ट मान जाओ कोई मैटर तो नहीं वो फिर मुश्किल खाली है 6 मार्च टेस्टमेंट किसका है? अच्छा 6 मार्च नहीं ऐसा भी नहीं ले सकता ऑल मैटर बोला ना नहीं सीधी डिटरमिनेशन मार्च में मार्च 3 p.m. 2 p.m. Then I am fixing two dates, 6th March at 3 p.m., 11th March at 2 p.m.
6 March,
6 March at 3 p.m.
3 p.m.
and 11th March at 2 p.m.
11 March at 2 p.m.
2 p.m.
Lordship,
And you have to complete this.
Lordship.
By 11th,
Lord, I shall try
you
to
do one thing, you come with
Lord,
the
I
data.
have taken enough time, my lord. I want to complete it.
Correct.
Yes.
Because now they have to give answer also.
No. That is right, my lord. That is right. Lord, that is the justification of saying by your lordship. Always we have to look into that.
So and so appearing for the plaintiff, so and so appearing for the defendant. Counsel for the defendant argued at length, but due to paucity of time, argument could not be completed. Fix on 6th March 2024 at 3 p.m. and 11th March 2024 at 2 p.m.
Lord, I am doing your best.
Next.
I am appearing on behalf of the petitioner in GA3, Your Lordship. Our arguments were completed way back in 14th August 2023. And the plaintiff is yet to reply, Your Lordship.
Which one?
GA3, Your Lordship.
Item number? Who is for the plaintiff?
I'm for the plaintiff. My lord, there are now, my lord, IA number 3 has been filed by the defendant number 6. Now, my lord, my first submission before your lordship is this, that in the month of July 2019, my learned friend had taken out an application being GA number 1496 of 2019. My lord, this application was for extension of time to file written statement. And my lord, the summons of the suit, my lord, as would appear from the said application, was served on 1st April 2019. And by
yes.
And they had sought for 4 weeks time. Such extension was granted.
Who?
By the honorable court, my lord, to file written statement.
This application is filed by whom? GA3?
Defendant number 3.
GA3 is filed by?
6.
Okay.
And my lord, thereafter they did not file any written statement in terms of the order.
Who has not filed? Defendant number 6.
6 to 14 have not filed any written
Extension
statement.
was granted by this court.
Extension was granted in favor of the defendant number 6. It was not filed, my lord.
Where is the order?
My lord, our applications are pending for extension of time to file the written
That is from 7 to 14. That have been taken out very recently, my lord. Very recently. Before that, they have not. So far as the defendant number 6 is concerned, my lord, the application was made long before, in 2019 only. And my lord, in their written application also, they have admitted the fact that such an application has been filed. And time was allowed to file written statement, and that was given go by.
My lord, I am appearing in GA3.
And I am appearing in GA1, but let Mr. Bose is more prepared in for so far as GA3 is concerned.
GA3 is taken up.
Yes.
3.
3.
Because 3, defendant number 6 has filed, he has argued the matter, now the plaintiff has to argue. You are for the plaintiff?
Yes, I am for the plaintiff. In GA3, if your lordship will take the application, well, kindly look at the prayers in the application. Completely different. Thanks. Just a small trivia. Mr. Bose, in an exactly identical suit, where I have filed the order 7, I have filed the suit, he's filed the order 7, rule 11. I want to see how he defends. I'm very intrigued by this. The prayer will, the prayer makes all the difference. Here he seeks, your lordship will see, he seeks deletion.
Without the defendant, the suit is to be.
Now, my lord. My lord, kindly see. Lordship will see. Now, my lord, kindly see the plaint. My lord, the entire plaint case is that, my lord, this was a joint family business. And my lord, kindly have a look at the genealogical table which is appearing at page 52. Now, which is the page number? There are 2 page numbers. This one or this one?
Yes, 52.
35. My lord, there are 2 paginations. Kindly ignore the pagination on top. My lord, their case is that this company who seeks to be now expunged, saying that there is no cause of action against them, they say that this is not a joint family company. Well, kindly have a look at page 35. Your lordship will see this is the genealogical table of the family. Well, if your lordship will see the from the extreme right, the second name from the extreme right, Mulchand. Now, my lord, the branch of Mulchand, your lordship will see
Indra Kumar, Ashok Kumar.
There's the second name after Mulchand is Indro, Ashok, and then below that is Ayush. And my lord, Kusum is wife of Ayush. Now, my lord, kindly consider this. Now, my lord, your lordship will see this company, its name is Karni Exports. My lord, the very fact that Karni Export is a family company incorporated by family members all along was a family company. My lord, the shareholding structure, the directors were all family company, were all family members. So that will be evident from 2 things, my lord. I have prepared for your lordship's convenience. Where's my brief? Prepared for your lordship's convenience. I have a copy. Well, from the portal of the Ministry of Corporate Affairs, your lordship will find 2 things. One is a list of directors, one the list of shareholders. I'll give your lordship a copy of each. My lord. I'll give all the second copy. Just give me. My lord, first kindly take the shareholding pattern. Karni Exports Private Limited. My lord, start from, if your lordship just runs through the financial year 2003-4 onwards, till the current year, your lordship will see the Rathi family, and if your lordship tallies this with the genealogical table, your lordship will find that in effect, this has been all along been the company owned and controlled by the Rathi family.
Yes.
All of them, all of them. If your lordship will continue, 100% shareholding is there with the Rathis. And my lord, there are certain companies that your lordship will find towards the end, certain shares have been allotted to companies. Now, these companies, if your lordship comes to the last financial year 22-23, your lordship will find there are one company is Ashok Kumar Rathi HUF.
Yes.
So there's an existence of a Hindu undivided family of which Ashok Rathi is the Karta. Then your lordship will find Danish Agro and Danish Dairy. We've got Danish Agro and Danish Dairy, again owned and controlled by the Rathi family, members of the Rathi family.
Where from?
My lord, if your lordship will see
Danish, yes.
Karni Export, the shareholding pattern, the last page of the shareholding pattern for the financial year 22-23, the last page of the shareholding pattern,
Yes.
you will see. And my lord, kindly see the name of the shareholders. Your lordship will see the serial number 4 is the HUF, serial number 5 is a company.
Yes, yes.
And serial number 6 is also a company. These are also defendants in the suit. This would be, I'll give you lordship, Danish. So this is defendant number 8 and 9 in the suit. Cross-holding. Well, their entire object is the family had cross-holding of shares. These are all companies owned and controlled by the family. These are all joint family businesses. And this is how, and my lord, the entire business, the assets are all belonging to the joint family, brought to the common hotspot of the joint family. This is my case. Now, my lord, if your lordship will see, Danish Agro and Danish Dairy, these are also parties to the suit, which is defendant number 8 and 9, and 100% shareholding and a management due to the directors of these two companies are also rather Rathis. Now, my lord, kindly have a look at the shareholding pattern. Hey, the directors. The other list which I have handed over to your lordship. If your lordship starts from the first financial year, lordship will see Ashok Rathi and Mulchand Maheshwari. Actually, Maheshwaris are also Rathis, I'm told. So some uses Maheshwari, some uses Rathi. So, my lord, this is acceptable in the Marwadi community. My lord, Ashok Kumar Rathi, if your lordship will see, the branch that I showed your lordship from the genealogical table, your lordship will see, it's all from the Rathi family. Now your lordship will see the director list continues. And if your lordship takes the last 2-3 financial years, the last page 21, 22, 22, 23, Ashok Rathi, Durga Rathi. Ashok Rathi, Durga Rathi. Durga is the wife of Ashok Kumar Rathi.
Yes.
And my lord, kindly see who's the plaintiff from the genealogical table. Ayush. Ayush would be, my lord,
Indra Kumar.
Indra's son.
Yes.
Same family, same branch. Well, this is the nature of the cross-holding. Well, so this by itself makes it abundantly clear that each of the company are effectively, they have been implemented. Why? Because the assets and properties of the joint family are held in the name of these companies.
Yes.
So, my lord, effectively, they are proper and necessary party. And this is the case that I have made out in the plain. So, my lord, today, if your lordship will seize the application.
What is the suit for?
Partition. Partition. Joint family partition. Now, my lord, if your lordship will kindly come back to once, the application once, it's a short application. Well, my lord, in fact, from the genealogical table, my lord, I don't want to trouble your lordship with that. Ganga Bhishan is the original, the ancestor of these of my plaintiff and the others.
Correct.
So now, my lord, same family. Now, if your lordship comes back to the application, para 5 says, from the cause title, it appears that the plaintiff has implemented the promoter director of this petitioner. That's the company. The petitioner is the company. Ashok Kumar Rathi and certain other shareholders. So this, on this statement itself, the application deserves to be dismissed. So that by itself makes the company a necessary party in view of the, the assets held by this company, and it forms a part of the joint family property. The plaintiff does not disclose any cause of action against the defendant. Then, my lord, it is not in dispute and clearly admitted that the petitioner was incorporated Ashok Rathi and Narayan Das Rathi. That's exactly what I'm saying. In 1987, each holding 150 shares. Never availed any money from the family corpus. This needs to be proved. It's a triable issue, cannot be decided at this stage. Petitioner is already suffering an order of status quo. Well, no appeal, order of status quo has reached a finality. It also, my lord, it is also binding upon the defendant which is applied. The present applicant, the status quo order is binding on that also. Give me the status quo order. Has not challenged the order. So there's an admission that there's no challenge to the order. And this party, defendant, has already applied and sought for extension of time to file written statement.
Yes.
And my lord, kindly have a look at the plaint which forms a part of the application. Kindly have a look at the plaint that forms a part of the application. And this is exactly I'll just show your lordship a few paragraphs. That's all. Paragraph, kindly see how it starts. Paragraph 5, 6, and 7. And this is how like your lordship has come across several these kind of joint family businesses, especially in the Marwari community. My lord, they have make several companies. And there are cross-holding of shares in this company. And by interlocking of shares, my lord, it all comes back, my lord, it's like a pyramid. It all goes back to one person, the person who's created it. And my lord, family members are shareholders, family members are director, family member and their nominees. It necessarily need not be a family members. Family members are nominee, their nominees are directors. So they have 100% control over the company. These are all private, closely held family companies. 100% control on the shareholding, 100% control on the management. So this is basically one economic entity, what we usually say, one single economic entity. So the assets which are held by these companies are effectively, these are all assets of the joint family property.
Okay.
Well, this is the order of status quo. It's not a part. Well, this is still subsisting. 3rd April 2019, no appeal. And my lord, no, do you have the extension order?
Yes.
So, my lord, if your lordship will kindly see the case that I have made out. Now, if today, my lord, kindly see if one defendant is considered to be not a necessary party, then none of the defendants, which are companies, would be a necessary party. Now, I have made out the case. My lord, if I just show your lordship that paragraph where I made out the case, that these are joint family companies and these companies have all been set up by the members of the joint family. My lord, I have indicated my lord, how the family has evolved over the years and how businesses have grown. Then, my lord, if your lordship will kindly take paragraph 20, 21, and 22. I went to America, that's not relevant. My lord, kindly take para 22. GA. No, this is no. Give 125, not 6. No, kindly take para 22.
Yes, I am on.
In course of such joint family business, lands were purchased in the name of the companies and firms being defendant number 6 to 18 and were owned and controlled by Hindu undivided family, and lands were purchased and divided. Shareholding of the companies 6 to 15 are held in the name of the parties. The number of allotment of shares in the individual name was made as per instruction of the defendant number 1. However, at all material time, it was represented by the defendant number, both the defendant number 1, such and such. They are LLPs as well. So this is my case. So I have to prove it in trial. If you go away, what about the asset? So the asset that this company owns will go away. And my lord, in any way, your lordship has seen the application. My lord, this is nothing but an afterthought to seek extension of time to file written statement. They're hopelessly out of time in filing written statement. And the principle, my lord, no, I am not a proper and necessary party. Now, my lord, proper and necessary party in my respectful submission is a test which has to be born out of the cause of action made out by the plaintiff in the suit. I am the dominus litis. I have made out that cause of action in the suit. So today, based on the cause of action, you have to say that I am not a necessary party. So these are my respectful submissions.
Lordship, Mr. Mitro is leading me. If your lordship may keep it tomorrow or day after. So any day subject to lordship.
There is one just statement in the affidavit in reply, which I may just indicate, possibly. If your lordship will take into consideration last sentence of paragraph 5 of the affidavit in reply.
Yes.
This has come for the first time in the reply when we've taken the point. Well, just kindly about 5, where the paragraph 5 ends, my lord, kindly take about 6 sentences from the bottom, about 6, 7 lines from the bottom. The petitioner states that at the nascent stage of the present suit, the petitioner had filed an application before this honorable court for extension of time to file written statement. This was subsequently allowed by this court for a further period of 4 weeks, not filed yet. However, after holding several conferences with the advocates of the petitioner, the representative of the petitioner had been able to convince on the factual aspect that the petitioner is not a family company under any circumstance. Thus, the petitioner had given a go-by. To what they have given a go-by, I don't know, my lord, but they should give a go-by to this application is all that I can say.
Yes.
May I come back tomorrow or day after?
That is the problem, sir. I have fixed the matter specifically.
Well, they can file their note. We'll file a 1-page
But
note
they
and
are-
finish it off.
Only the reply.
Yes.
Give the written notes.
Will if your lordship may give us 2 days time, then we'll come with the note and give the reply.
Problem is the date only.
Date is the main problem.
Problem is the date with this court.
No, just 5 minutes, your lordship. We'll give
For
the
an
note. We'll
application
give
of
the
this
note.
nature, it's a partition suit. They have not filed written statement. It's been more than 4
That your
years, 5
lordship
years.
has allowed. That an application has been filed, your lordship has they have sought time to file their opposition. That is pending.
So defendant
That
number
is
6.
Not 6.
No, 6. This application is pending. Because of this application is pending, we have not.
6, already the court has granted time, but you have not taken the benefit of that.
4 weeks time, they have sought for extension.
You have not taken the benefit of
You cannot circumvent my suit. My suit has to go for trial. Hey, judge's brief is ready.
What is the stage of the
certificate?
What is the stage of the suit?
WS has been filed by 1
It's fixed.
1 to 5 are filed written
When
statement.
it is fixed? Not fixed.
Not-
Matter is returnable.
applications are, my lord, my opposition is ready.
Which one?
4 to 9.
No,
The lordship-
today
Application to.
Your lordship, application has been filed by the defendants for extension of time to file written statement, which your lordship has kept returnable on 20th of this month.
20th March.
28th of this month.
28.
This month.
This
February.
February.
There is no application on behalf of the defendant number 6. May I file my
Which,
opposition?
in which application?
GA4 to
GA4
9.
is there.
Yes.
No, those are not there appearing. It's due to returnable on 28th.
It is on 28.
May I take your lordship leave,
Yes,
my
sir.
great.
So and so suffering for the plaintiff, so and so suffering for the defendant. Full stop. The defendant number 6 has filed the application being GA3 of 2023, praying for deletion of their name from the cost title of the print, their name from the print. Full stop. Counsel for the plaintiff has concluded his argument. Full stop. Counsel for yes, Mr. Mitra has come.
My lord, I missed halfway submissions. Can I just give me 2 days time, my lord? I just have.
Counsel for the defendant. Full stop. Counsel for the defendant number 6 prays for time to give reply. Let the matter appear and give the date. 5th. What time? 5th March 3:45.
And my lord, we'll also file a note, my lord, to the.
I think the parties are directed to file the written notes of argument on the date fix. Take note of, madam. File the written note.
Grateful, my lord.
My lord, in this matter, I am appearing on behalf of the plaintiff, your lordship. My lord, on the last occasion, your lordship has given time to file the necessary pleadings because it is a transfer suit to the commercial division, your lordship. My lord, it could not be completed. I am only seeking for 1 week's time, your lordship. It is almost
This is the
ready.
problem here. Henceforth, I will dismiss all the application in the.
No matter. Kindly 7 days time. In the meantime, it will be affirmed.
Application, you take your time.
My lord,
Case was
kindly.
transfer January 4. Then 7th February, you have taken time. We are on 26th, 20 days has been passed.
My lord. My lord, kindly give me 7 days time.
As per the prayer made by the counsel for the plaintiff, time to comply with the order dated 4 January 2024 is extended for a further period of 1 week. This is the matter on 7th of March.
Grateful.
Next.
My lord, I appear for the defendant.
Yes.
My lord, my witness is here, my lord.
Present.
Yes, my lord.
Who is for the other side?
Mr. Shomavu Ghosh was appearing for the plea.
Yes.
First.
English
and part of it. English and Hindi. कुछ नहीं तो मैं हिंदी में ज्यादा अच्छे से बोल सकता हूँ.
Defendant.
Yes, my lord, this suit was decreed in September 2018. My lord, thereafter, we filed an application in the form of a review as well as with an additional prayer for mandatory injunction directing the plaintiff to repurchase my stock, repurchase their stock essentially and give price adjustment. My lord, that application, your lordship was pleased to dismiss that matter, my lord, that SPX Power Tools. Written statement.
मैं शपथपूर्वक कहता हूँ
मैं शपथपूर्वक कहता हूँ
इस मुकदमे में
इस मुकदमे में
गवाही के तौर पर
मैं गवाही के तौर पर
जो कुछ भी कहूँगा
जो कुछ भी कहूँगा
सच कहूँगा
सच कहूँगा.
सच के सिवा अच्छा मिस्टर घोष विल नॉट
सिवा कुछ नहीं और कुछ नहीं छुपा.
आपका नाम
संजय जैन.
स्पेलिंग बोल दीजिए.
SANJAYJAIN.
पिताजी का नाम
लेट श्री मोहनलाल जैन.
मोहनलाल
MOHANLAL.
उम्र
60.
क्या करते हैं
बिजनेस.
एड्रेस
215 शरद बोस रोड 21 कोलकाता 26.
Written statement. Whole first volume. First volume.
Lord, I appear for the plaintiffs.
But in fact, my lord, may I make one suggestion? My lord, I have received my learned friend's admission and denial of documents. My lord, I see some of the documents, contents, and existence have both been admitted. If my learned friend does not have any objection, my lord, I have gone through the serial or the list that they have provided. My lord, those documents can be marked as exhibits because they have already admitted the existence and contents of the document.
If it is admitted, it can be.
Yes, my lord. Right now, I will not trouble your lordship. May I proceed with the examination in chief?
क्या ढूंढ रहे हैं?
Volume 1.
Volume 1.
Shown the written statement, Gurudin. I am showing you a document. Please see this document and please tell what is this document.
Written statement volume.
Don't surprise me.
Written
statement. Just এক্ষুনি দিয়েছি। Volume 1.
कहाँ?
Can you please tell what is this document?
This document is submitted by us through
judgment
Advocate Fox and Bundle.
on the matter in part
Through
or election law. Fox and ये तो होगा ना तिलक बोस का नहीं उसका है ना.
My question to you is, what is this document?
अनिल मित्र और एक है ना
इंग्लिश बुझতে পারে।
So this is the application. This is the what? Document suite file. Admission लेना है बताओ। बाकी तो this is the application bullet. This is application. So let it go down. This is a suit filed by us.
This is the application. Full stop. Then witness says, "This is the suit filed by us."
Sir, can you
Please come to.
Sir, can you guide us? Actually, this is the actual papers. Actually, first time I came in the court, sir.
Okay, whatever stated, that is in record.
Please come to the cause title of this document and please tell who are the parties to the present proceeding.
Sir, can you speak in Hindi?
आप एकटू ट्रांसलेट कर दें।
आप उसमें देखिए कौन कौन पार्टी है उस एप्लीकेशन में।
इसमें XPX Flow Technology and Sanjay Jain.
There is the party that's HPX Flow Technology. SPX Flow Technology. Singapore.
SPX Flow Technology Singapore, PTE Limited.
And
Plaintiff Sanjay Jain.
You have deposed that Sanjay Jain is the defendant in the present proceeding. Am I correct?
Yes, sir.
Please see page 2 of this document and please see page 2 of the document and please now tell what this document is.
So the suit filed by plaintiff.
and the various issued to the Honorable Court.
Whatever the issue, it is written in the on there. Whatever the issue is, that is written on page number 2.
Please come to pages 44 and 45 of this document. Do you find any signature appearing at page 44 and 45 of this document?
Yes, sir.
पेज नंबर 44 और पेज नंबर 45 पे आपको सिग्नेचर दिखाई दे रहा है?
हाँ, sir.
Yes.
दिखाई दे रहा.
Please tell whose signature appears at page 44 and 45 of this document.
Mr. Naval Chajer.
Naval, N-A
VAL.
VAL CHHAJER.
Who is Mr. Naval Chajar?
He is my nephew and he has signed with my permission and my
He
instructions.
is my nephew. He has signed in my presence. No, he has signed.
Presence.
He has signed
on my instruction.
on my instruction.
You have deposed that Mr. Naval Chajar has signed this document on your instruction. Will you be in a position to say what is this document that has been handed over to you?
This is the power of attorney affidavit. This is affidavit. No, this is the affidavit.
This is the power of attorney. Full stop. Then says this is the affidavit.
Mr. Naval Chajer signed the document in the court.
What is the document at page 44? Page 44.
This is affidavit.
Do you find any signature on the affidavit that you have identified?
Yeah, I can identify this.
Don't say yeah.
Yes.
Yes.
Can you please tell the name of the person who has signed at page 44?
Naval Chajer.
Can you identify the document appearing at page 45?
Yes, sir.
Please tell what is the document which appears at page 45.
The declaration.
Do you find any signature at page 45?
Yes.
Whose signature appears at page 45?
Mr. Naval Chajer
Who is Mr. Naval Chajar?
is my nephew.
Can you please tell why Mr. Naval Chajar has signed on page 44 and 45 of the document that you have been handed over?
To submit the documents to the Honorable Court
Submit the document before this honorable court
on my behalf.
Why Mr. Naval Chajar has submitted these documents on your behalf in this honorable court?
Because I have authorized him to submit the documents and I have given you authorization.
I had given authorization to him.
You have deposed that you have authorized Mr. Naval Chajar to submit documents in this honorable court.
Yes.
How have you authorized Mr. Naval Chajar to submit documents before this honorable court?
कैसे ऑथराइज किए थे उनको इस डॉक्यूमेंट में इस कोर्ट में ये डॉक्यूमेंट सबमिट करने?
I have given power of attorney.
Then I have given him the power of attorney.
Competency to them. Competency, affidavit of competency.
अजी क्या डॉक्यूमेंट चाहिए?
আমাকে একবার দেবেন? আমারটা দিয়েছি। না 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 না, হ্যাঁ 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 ভাবি।
আমার লাগানো চা
হুম। I am showing you a document. Please see this document and please tell what is this document.
This is power of attorney.
Do you find any signature on the document that has been handed over to you?
As on page 3. Signature is there.
Yes, there is a signature on page number 3. There is a signature on page number 3.
Who has executed this power of attorney?
Mane, Sanjay Jain.
I have.
I have signed the.
I have signed the documents.
Whom have you appointed as your attorney in terms of this document?
पावर ऑफ अटॉर्नी अपॉइंट किया है इस डॉक्यूमेंट्स के जरिए.
Mr. Naval Chaje.
Are the contents of this document true and correct?
Yes.
Huh? No, no. এবার রিটেন স্টেটমেন্টের ভলিউম না ভলিউম হ্যাঁ পেজ 50 হ্যাঁ হ্যাঁ আমি রিটেন স্টেটমেন্ট থেকে দেখা পেজ 50 দেখান পেজ 50
50
অরিজিনাল কোনো কথা A1 and A2. I am showing you two documents which are appearing at page 50 and 51 of the written statement. Please see these two documents and please tell what are these documents.
ये email है.
This is a email copy.
Please don't put in words. Yes, said email.
This
This is an email copy.
What is the date of the email that you are looking at?
9th June 2016. And 16th June 2016.
Will you be in a position to tell who has issued these two emails dated 9th June 2016 and 16th June 2016?
I have sent this email from my company mail ID.
I have sent from my company's email ID.
Will you be in a position to say to whom did you issue the emails dated 9th June 2016 and 16th June 2016?
I have issued to the plaintiff vice president, Mrs. Jenny.
I have issued these two emails to the vice president of the plaintiff, Mrs. Jenny.
Jenny. NNY.
Jenny, Jenny.
How did you obtain these emails dated 9th June 2016 and 16th June 2016?
I have taken from my company mail ID from my computer attached with the printer. I have taken the printout.
I have taken the
My computer attached with the printer.
গেছে? Where are the originals of the emails dated 9th June 2016 and 16th June 2016?
This is the printout of the original email.
Are the contents of the emails dated 9th June 2016 and 16th June 2016 true and correct?
Yes.
Let may it be marked as exhibit
yes, Mr. Ghosh. Exhibit 1.
one and
Collectively.
exhibit 1 collectively. দেখো ফেব্রুয়ারি হ্যাঁ হ্যাঁ ঠিক আছে রাখুন, কোনো অসুবিধা নেই, রিটিন স্টেটমেন্টে রাখুন। হ্যাঁ রাখুন রাখুন, অসুবিধা। I am showing you the documents which are appearing at page 52 and 53 of the written statement. Please see these two documents and please tell what are these documents.
This is an email copy.
How many emails are you looking at?
2. Sorry. Yeah, 2.
Yes.
Yes.
Will you be in a position to indicate the dates of the emails copies whereof have been handed over to you?
14th January 2016.
2016. Which is appearing at page number 52. Already there. Only date to record the date.
And 17th February 2016.
Page number 53.
Who has issued the emails dated 14th January 2016 and 17th February 2016?
I issued.
To whom did you issue the emails dated 14th January 2016 and 17th February 2016?
I issued these 2 emails to the president of Plaintiff Company.
This email to the president of
Plaintiff Company.
How did you obtain the emails dated 14th January 2016 and 17th February 2016?
From my mail ID from my computer.
from my mail ID and from my computer.
Where are the originals of the emails dated 14th January 2016 and 17th February 2016?
In my computer, my company mail ID.
Are the contents of the emails dated 14th January 2016 and 17th February 2016 true and correct?
Yes.
Let me it be marked.
This can't be exhibited yet because the compliance of 65B has not happened. Is to comply because electronic mails, so may not be.
Have you filed the 65?
We
No,
have
but-
not.
Not filed.
Admitted without contents.
But my lord, it has been admitted. The
Contents are denied. So he has to
existence
prove-
has been admitted. Existence has been admitted.
does not mean it will be exhibited. He has,
Yes, it can be exhibited subject to objection.
Two collectively, subject to objection.
Huh?
C1 and C3.
এটা আমি জিজ্ঞেস করছি।
C1 and C3.
দিয়ে দাও।
Yes, next.
Sanjay Jain.
I am showing you documents appearing at page 54 and 55 of the written statement. Please see these documents and please tell what are these documents.
54 and 56. C1 and C3.
Oh, 54 to 56. Sorry,
And 56, not 55.
not 55. Oh, 54 and 56. I'm sorry.
54, 56.
54 and 56 of the written statement.
Yes, what are these documents?
These are the mails. My lord, these are the mails.
Do you find any date mentioned on the document appearing on the emails that have been handed over to you?
Yes, 11th June 2016 and 2nd July 2016.
Who has issued the emails dated 11th June 2016 and 2nd July 2016?
I have issued, my lord.
To whom you have issued these emails dated 11th June 2016 and 2nd July 2016?
The Vice President of Plaintiff Company.
Will you be in a position to indicate how did you obtain the emails dated 11th June 2016 and 2nd July 2016?
I have taken from my company email attached with the printer. I have taken the printout.
Are the contents of the emails dated 11th June 2016 and 2nd July 2016 true and correct?
Yes, my lord.
My lord, this may be marked as
similar objection.
yes, similar objection.
Three collectively, subject to objection.
Yeah.
अरे हमारा वो है अनुतोष कोई आदमी है हमको पाँच
Copy that. I am showing you a document which is appearing at page 78 of the written statement. Please see this document and please tell what is this document.
This is an email.
Will you be in a position to indicate the date of the email?
20th April 2017, my lord. 20.
20 April 2017.
Who has issued the email dated 20th April 2017?
Mrs. Sudatta Ghosh.
Sudatta Ghosh. Who is Sudatta Ghosh? Sudatta Ghosh.
She is my company employee, my lord, as sales coordinator.
Why did Sudatta Ghosh issue the email dated 20th April 2017?
She had issued the email on my instruction and my guidelines.
How did you obtain the email dated 20th April 2017 issued by Sudatta Ghosh?
I have taken from my company email ID from my computer and taken the printout from my attached printer.
Can you please tell to whom did Sudatta Ghosh issue the email dated April 20, 2017?
To the sales manager of plaintiff company.
Are the contents of the email dated April 20, 2017 true and correct?
Yes, my lord.
But this cannot be exhibited, my lord. Not with an objection or without an objection, this cannot go in because this is not the witness's email. He is not the originator. He doesn't have access. He has not said that he has access. So all these
Yes,
things.
he has.
No, he has
No, no.
stated that on his instruction.
Yes.
Maybe.
And
But on his
guidelines.
instruction does not
And
mean that
guidelines.
will give him access to this email. He can't.
But kindly see, my lord, the objection. But kindly see the email from which the email has been sent.
Yes.
It is, he says, it is the company's email ID from which the email was sent. The email ID has been indicated at page 78 of the written statement, jtc@cal2.vsnl.net.in. It is not a personal email account from where, my lord, he had to, my lord.
My lord, may I say this? This is exactly the point. It has to be contradistinguished between pages 52 and pages 78. Lordship sees that. An email which he has issued is at page 52. And the email, which is according to my learned friend, the company email, is a separate email ID. Now, he cannot say that he has issued this email. Maybe under his instructions. There's nothing to establish what instructions he had.
Yes, Mr. Both.
If somebody has to prove the person who has issued the email, that person has to come forward.
I'll put appropriate questions to prove. These objections, my lord, are neither here nor there.
It is somewhere.
Very well. How did you obtain the email which, according to you, has been issued by Sudatta Ghosh to the plaintiff?
From my company mail ID.
Can you please tell how did you access your company's email address and obtain the document that is the email of 20th April 2017?
How did you obtain this mail ID from your company's mail ID?
Interpret. My question to you is, how did you obtain this email by accessing?
Accessing is
No.
He didn't say
that.
Please repeat the question. May I put another question?
Get it then.
Can you please indicate how did you obtain the email dated April 20, 2017, which according to you was issued by Sudatta Ghosh by accessing the email address that is jtc at cal2.vsnl.net.in.
Is not stated with regard to the mail ID. You cannot
Yes.
put.
Very well, but I'll again
You
put another
another question.
Can you please tell how did you obtain the email dated 20th April 2017, which was issued by Sudatta Ghosh to the plaintiff?
I have given access to my email, company email ID to Sudatta Ghosh, and she has sent the email on my instruction and my guidelines.
Can you please tell how did you obtain this document, that is the email dated April 20, 2017?
I have taken from my print. I have taken from my company email ID. I have taken the printout. This is the government email ID issued by VSNL, registered in my company name.
Do you have any objection now?
Yes.
শোন না না এবার দেখো ছবিগুলো দাও দাঁড়াও দাঁড়াও পরে ও এখন ঝামেলা করবে
Mr. Basu,
Yes,
it will take time.
yes, my lord, it will.
Let it close here.
But may I do this, my lord?
Ah.
There have been, as I was saying,
Yes,
my lord, my
Mr.
chief
Mr.
can be
Ghosh.
shortened.
Yes. You go through the admission and denial. What are the admitted document? You come with that so that that can be exhibited. It can be sorted out.
My lord,
It is
only
admitted by the parties.
yes, that can be only to the extent, my lord, that wouldn't prove the content.
Subject to proof.
No, he has admitted the contents as well as the existence.
Existence and content.
Existence. That's why the
Yes, I am
admitted
only
document with
indicating
regard
those documents.
admitted document with regard to has a whole.
Because, my lord, page 55 of my written statement is an email of 13
Okay,
June
okay,
2016.
you sit
I'll just
together.
speak to him. We'll sit across the table
together.
and we can resolve this issue and
What
come
are
back.
the document which is admitted as a whole? That
Yes.
can be.
Yes.
Whatever I have
This is the plinth, madam.
This is a plate, madam.
এটা যে লিখে দিন।
হ্যাঁ, এগুলো
This is the
যেমন-
plinth.
যেগুলো exhibit mark হয়নি সেগুলো ফেরত নিয়ে নাও। My lord should kindly give us a date, my lord.
Mr. उतर जाइए।
आप उतर जाइए।
Consultant appearing for the plaintiff, consultant appearing for the defendant. Defendant witness is present. Examination in chief started. During this examination, two documents were exhibited, being exhibit 1 and exhibit 2, collectively with objection. Due to paucity of time, examination chief could not be completed. Examination chief is deferred. List the matter on. Give the date. 8 March at March. 8 March.
March. So my witness is here.
Yes.
Closing question. बता दें। Sir, your name?
Shiv Kumar, yes, sir.
ID.
ISSAR.
Yes, sir. So, SR, on the last occasion, you have shown the email dated February 19, 2013. Appears at page 90 of the judge's brief of document.
Can I have it?
So,
I'm at page 90.
You had sought time on the last occasion, saying that since you are not part of the email chain, you need time to indicate to this honorable court as to what is the amount that is appearing in this email.
So there are various amounts which are appearing in the email, which is dated January 14, 2013.
The Mr. Esar, the amounts that are appearing in the last paragraph of page 90. Page 90.
Is there?
Last para, page 90. Page 109 টা খোলো তো।
So the last paragraph on page 90, INR 11 lakhs plus.
Yes.
INR 11 lakhs plus.
What for was this amount agreed to be paid to the plaintiff?
So everything that was been to be paid to Mr. Vivek J. Agarwal has already been paid. Vivek J. Agarwal has already been paid.
When was it paid according to you, Mr. SR?
Through the full and final settlement document. Should I need to indicate that?
It's your wish.
Oh.
Last 2 years ago? হ্যাঁ ওটাই বলছি তো ডকুমেন্ট পেজটা সময় নষ্ট হচ্ছে জানো না ইউ নো ডোন্ট ইউ পুরনো ব্যালেন্স সেটেলমেন্ট পেজ নাম্বারটা লেখা আছে না নেই I think the document we're looking for is at page. May I indicate his answer?
Yeah,
Just
please.
page 70, I think.
70?
70.
70?
70. I think the document that
70,
he's searching for is at page 70. 70.
Yeah, thank you very much.
Even with the date.
No, with regard to the question, that this is the document which can be show that the total payment was made to the plaintiff.
পড়াশোনা করাইনি
So it's part of that, sir. My lord, there's another document which was signed by him, which is a full and final payment sheet. I'm just looking for that. So the full and final settlement.
No, he has shown that document. Whether
It's a
you are
part of-
searching this document.
This is another document, sir.
So what is the total payment?
document গেল done. You are not aware of it. There is a thing that you can assist. They have like an action.
Give the exhibits.
জানি না কোনটা খুঁজছে কি করে জানবো ওটাই 140 145 এটাই হবে এটাই হবে $1,445. That is the document I think we are looking for.
Yeah. Thank you very much. 145, page number 145.
Now tell your answer. What is the total amount?
So this is the total amount of 13 lakhs, 13.14 lakhs.
When, according to you, was the settlement amount paid?
So through a letter dated 19th June 2012.
And what is the date of the email that I have shown you at page 90?
So it's by Vivek J. Agarwal on 19th February 2013.
Is there any reply to this email by the recipient of the email?
So after 19th February 2013, I see no email in this document, in this set of documents.
You have earlier deposed Mr. SR that the email of 19th February is in reply to the email dated 14 January 2013.
Mm-hmm.
So why did the defendant admit the payment post the settlement?
So this appears to be a kind of unidirectional follow-up, post the acceptance of full and final payment by Mr. Vivek J. Agarwal.
kindly take your deposition of 6th of December 2023. And also take page 109 of the judge's brief of document.
Show 109 of the judge's brief document.
Can you indicate to this honorable court the period when the profit was made by the defendant according to this document?
Which question here?
Yes, 109.
You go to the 109, not to the deposition.
Yeah,
Yes.
I have this.
109. The period for profit. I'll just take 2 minutes.
No, continue, no problem.
So the profit?
The period when the profit was made.
So year ended March 31, 2011, and period ended 31, 2011, and period ending March 31, 2012.
Profit, only profit. The question is shune nahi. When the profit was made.
So in the year 2011, the profit was 2298833.
Is
98833, and the amount in 2012 is negative 56,470. 56,470,360. 660.
Was the plaintiff in the service of the defendant when the defendant made the profit for the year ending March 31, 2011?
Yes.
And was the defendant, the plaintiff was in service of the defendant when the company made the loss for the year ending March 31, 2012?
Yes.
When did the plaintiff resign from the services of the defendant?
Let me check.
One more. May I help him out with the date?
What is the page?
30th. It's 30th November 2011. If you, it's there in the plaintiff.
30th November 2011. 2011. 11.
So that suggests, Mr. SR, that the plaintiff was not in service of the defendant for the whole of the financial year that ended 31st March 2012.
Not whole of the financial year.
But he was in service for the whole of the financial year ending 31st March 2011.
Yeah.
Mr. SR, I suggest that the defense of the defendant is not maintainable in the eye of law.
Can you repeat, please?
It's not maintained. Repeat correctly. Defense of the defendant is not maintainable in the eye of law. It's a suggestion. I suggest. Suggestion. Sujav, can agree or cannot agree?
It's not maintainable. It is maintainable. It's confusing. It's very obvious.
What the case you have made out in the written statement, that is not correct as
It's not correct.
Nothing will happen because of this. No issues. You can come down.
not agreed.
Not agreed.
Not agreed. Okay.
That concludes, my lord.
I have another witness.
How much time?
He has another witness, my lord.
I have another
This is over.
This is over, my lord.
Okay, please stop.
Thank you very much.
You will bring another witness?
Yes, my lord. I'll need some time because the person concerned, he's the financial head of the institution. So after 31st March, my lord, because the year ending is there, he'll need 10 days after 31st March to resolve everything and come.
Suffering for the plaintiff, suffering for the defendant. Defendant witness number 1 is present. Cross-examination resumed and concluded. Counsel for the defendant pressed for time to adduce further evidence. Let the matter appear. Give the second week of the second week of April.
Second week.
Time is taken. I will only request that no adjournment will be paid for.
No, my lord.
You know,
if it's after second week of
His coach will be very much happy to pay the cost even from his own pocket. It don't matter, my lord.
I'll take him out for coffee or something. I think he'll not oppose after.
coffee.
Hold. 4-course meal, my lord. Only then I can agree.
Okay, agreed.
Well, so I am. How much it will take long?
But I think it will take. I think if 2 dates are
I am
fixed
fixing 2 dates.
consecutively, yes.
Probably it can be, my lord.
But can it be then over the weekend instead of? Then he'll have to come and again go back.
That's right.
Yes. Very well.
In 17th April.
And probably, my lord, before 3:30.
16th or 17th April. 12 noon.
12 noon. Very well.
Well, indulgence, item number 5 of the commercial division, my learned friend, I see on the online. Only for filing.
The defendant will it.
Yes. File the suggested issue, we can come back at 2 o'clock or at the end of the board. Lordship is rising now.
Today.
Yes, item number 5, only for filing the suggested issue.
No, I had some issue with it, with the filing of the issues. I'll come back and whenever my lord is taking the matter, I'll come and address my lord.
I do not know, Miller. Issues have to be framed.
Issue is to be framed.
Yes. Not issues will be framed. But my difficulty is that my learned junior in the court has suggested issues. But also with regards to inspection and discovery, whatever we were granted inspection of, were merely copies of the plaint, except for 2 documents. But my difficulty is hereafter I will not be able to come back with the admission and denial affidavit. Therefore, I was pointing it out to court.
Not been completed.
Yes, she has taken Miller admission. These are all e-copies. 65Bs
No, Millard, I'm sorry to say, Millard, but the definition of e-copies, Millard, is not the same as the definition of what they are trying to paint it as, Millard. But these are vouchers and invoices which my learned friend's client has placed, Millard. The invoices are 85, 87 and thereafter, Millard. With Mr. Ghosh's leave, Millard, just indicate my difficulty, then Mr. Ghosh can address my lord. With my difficulty, Millard, I'll just impress, Millard. Millard, we understand electronic copies of documents as documents which are there in the electronic portal in the form of emails or even documents which have been, which genesis is electronic. Not that a person scans a copy and puts it in the electronic medium and in the computer and calls it electronic records. No, that is not what the definition of electronic record subject to correction is.
She will deny the document. She will deny the document.
Approved by the parties.
Yes, Millard, that is Millard. So now, Millard, with regards to admission denial, Millard, since I have not seen the original, neither the document itself, I have only seen the plaint copies. Actually, the paginated copies of the plaint has been shown to me, Millard. In that view of the matter, Millard, I do not know how do I make my affidavit of admission and denial. That is my predicament.
Subject to correction, Miller. If I, Miller, have shown Miller a copy which is not, Miller, admissible, So, my lord, both, my lord, the existence and the contents will be denied. I have to
Denied
prove it
that.
in the box.
You denied
Very well,
that.
very well, very well. Well, that means that apart from those first two documents, nothing has been shown, Millet. I will deal with it. Very well.
Because that's why the affidavit of admission and denial process
Yes,
is
Millet. Yes, Millet.
it.
Yes.
And at the time of
I have
exhibiting,
to
we'll see
prove
to
it.
that.
My witnesses
Well,
will
well, well, Millet.
Only for the defendant who is there, who is
No, Millet, what they were trying to, Millet, they were trying to take a garb of electronic records, and that is the reason why we have printed it out from the plaint and given it to you.
this
Lord,
court
may
is
receive
taking the
voice, my
evidence.
lord.
The electronic record we are taking on
Second,
record
deny
subject
the
to the
documents.
proof by the parties.
Yes, Millet.
In the 65B, it is the party has to prove that.
Yes.
65B is the one of the procedure which the electronic record has to come on record.
Yes,
That's
Yes,
all.
Millet, I will demonstrate that from the document itself. Now we'll kindly have a look at the document on that day and then decide.
Not
So
on
now
that
what
day
do you
at the time
want?
of hearing.
Well, the suggested issues are there with my learned junior. She can hand it over to the court because the court had wanted us to bring our suggested issues. That can frame the issues.
Admission and denial is filed.
No,
No,
not fine.
not yet. Well, we have completed it only on Friday, Millard.
Lord, we have, my lord, I have prepared it, my lord.
No,
Same way goes for
then I am
both sides.
fixing because unless and until admission and denial issues, then
Absolutely, Millard. Absolutely, Millard.
He has not filed. We
So,
have filed.
एक डेट दे दो छोटा कोई डेट
I have given my inspection only on Friday.
We have made it ready. We have come to court.
Okay, I am fixing day after tomorrow at 1 p.m. for framing of
Yes, Millard.
complete your admission and denial.
Yes.
Absolutely, Millard. Thank you, Millard. Deeply obliged.
The application pending that lordship has to hear.
What are the applications?
Lord, the injunction is pending, my lord. Lordship has to go this way or that way, my lord. That has to be heard of. And this is the bench, my lord. That bench can't.
First time that they are pressing their application for injunction.
Please, Mr. Shah, don't make these statements. First, there was an order, there's an undertaking, there's a further undertaking in the order.
You are Mr. Demnath, you are appearing for?
I am appearing, my lord, for the plaintiff. This time for the plaintiff. That's why I confused. This time, my lord, for the plaintiff. Normally, I get the defendant's grief, my lord, to my lord oppose.
Mr. Santos appearing on the counsel for the defendant. Press for time to file affidavit of admission and denial. So let the matter appear on, give the date, 28 February at 1 p.m. for filing affidavit of admission and denial of document and framing of issue.
And along with GA number 1 of 2020.
The counsel for the plaintiff submitted
2020.
one application being GA number
1 of
1
2020.
of 2020
Yes. It's a suit of 2020.
pending that the record of GA 1 of 2020 be placed along with CS number so on the date fixed.
Grateful. Much obliged.
Deeply obliged, Millard.
No adjournment will be granted.
That's always.
It's a previous matter.
Adjournment চাইলে এখানে cost দেন জজ সাহেব হেভি cost. Good. Great.
My lord, this is the matter I had mentioned that day, my lord. I was only praying, my lord, in terms of your lordship's previous direction, my lord, both the parties are to, my lord, carry out this exercise of admission denial, which is outstanding. My lord, this is to be done within, my lord, a period of 3 weeks. Lordship fixes it for witness action. The only other point I tried to, my lord, impress upon your lordship the other day was that possibly, my lord, according to my understanding, this would be a commercial dispute, and the, my lord, it has to be transferred and tried in the commercial division.
Lord, I appear for the defendant number 1, my lord. The suit has been filed in 2017. My lord, and my learned friend at this stage
Genuine
is coming up. Let him
objects.
take out an application if he desires, because
My lord, other courts, my lord, there are instances where, my lord,
I also.
lordship has also done that, my lord.
Also doing,
This will only, my lord, save some time, my lord.
if the objection is there, then
Affidavit भी तो है.
My lord, one thing, my lord, may I just indicate?
Very well, my lord. Lordship just
So far as my instruction is concerned, my lord, this is a suit for specific performance of an immovable property. The immovable property is presently being used as a residential purpose. If it is completely used as a residential purpose, then, my lord, the dictum of Ambalal Sarabhai cannot be relied upon in any manner. Now, my lord, this is my first submission. Now, my lord, so far as the admission and denial is concerned, my admission and denial is ready. I can file it.
I will do that, my lord, within a period of, my lord.
For the plaintiff.
I am for the plaintiff. You could say admission, you know.
No.
My lord, defendant number 1.
So appearing.
My lord, defendant number 1 and plaintiff is to, my lord, do that.
So appearing for the defendant number 1 and so appearing for the defendant number 2. The matter is listed today as for today for witness action, but the counsel for the plaintiff submit that the admission and denial of the document has not been filed. Counsel for the plaintiff and the counsel for the defendant number 1 raised for time to file affidavit of admission and denial of the document. Counsel for the defendant number 2 has filed affidavit of admission and denial.
And he is also raising objection that it's not a commercial dispute.
Counsel for the plaintiff submit that the suit is required to be transferred from this court to the commercial division as the dispute between the parties are commercial in nature. Counsel for the defendants raised objection.
Defendant number 2 only. One is not. One wants application. 2 says no commercial disputes.
Counsel for the defendant number 1 submit that simply this suit cannot be transferred from this court to commercial submit that simply the suit cannot be transferred from this court to the commercial division as the plaintiff has not filed any proper application for transfer. So the counsel for the defendant submits that the nature of the suit is not a commercial and counsel for the defendant number 2 submit that the suit is for a specific performance of contract and the property is being used by the tenants.
No, he says only for residential purpose.
By the parties only for the purpose of residential.
I am disputing this, my lord.
Purposes, but the learned counsel for the plaintiff denied the said submission made by the counsel for and disputing the said submission made by the counsel for the defendant number 2. In view of the submission made by the counsel for the respective parties, the plaintiff and the defendant number 1 are directed to file their affidavit of admission and denial of the document within a week.
My lord, some more time, my lord.
Within 2 weeks from date. As regard the transfer of the suit, as no application is filed, this court is not in position to decide as there is a dispute between the parties whether the suit is a commercial nature or is to be tried by this court. Please.
My lord is not fixing it for hearing because I am going to take out that application.
Is the matter on 14th March 2024.
My lord, if your lordship directs, I can file my
You
admission.
filed it. I have
14th
recorded
March,
that.
yes.
I'll circulate copies also, my lord. Okay, plaintiff है तो I know. One document of the admission denial नहीं. Grateful.
Yes, next.
My lord, the other matter, the 2 p.m. matter was also fixed, my lord, for tomorrow. Any specific, my lord, direction?
The suit is already also fixed tomorrow, but due to the circumstances mentioned above, the hearing of the suit has been
Deferred till 14th.
Hearing of the suit is deferred till 14th.
Grateful, my lord.
Is deferred. What is already given is deferred.
My lord, may I request the witness to step into the box?
My lord, before my learned friend starts, my lord, from the deposition, I was not there at the end closure of the matter on the last occasion, my lord. I find that my learned friend has re-examined the witness. Lord, my humble submission before this court is re-examination can only be done after closure of the cross-examination, which is continuing.
So cross-examination not completed.
No.
Cross-examination of defendant number
all the defendants
4A to 4C was complete.
But other has not been
It was only clarification of the question
No,
put by
that
that
cannot
defendant.
be, my lord. That has to be expunged.
It is required to be cross-examined.
Follow 6, 7, 8.
So you have not mentioned that.
Nobody raised any objection.
Nobody has raised objection. That's why
I am surprised, my lord.
nobody.
But I was not there, but as per section 138, my lord, that cannot be.
I accept this. Unless and until the total cross-examination not been done with part and part, it cannot be.
It cannot be done.
It cannot be.
My lord, in that even, my lord, question numbers 908 and 909 have to be.
My lord, I am raising objection. If she wants, my lord, expunging, my lord, let her take out an appropriate application.
No, my
and
lord,
deal with it.
this is something which is directly in contradiction to the statute.
My lord, not on an oral prayer. Let an application come.
It is not required. It is for me to point out to the court that the cross-examination is not complete.
But it has come on record. That is the problem, madam.
Well, that cannot go in.
That is correct.
I am raising an objection, my lord. Part and parcel re-examination cannot be allowed.
I appreciate your submission with regard to now this evidence has come on record. Nobody
It has to be expunged.
Expunged under which provision?
Well, this was brought in a wrong way, which is not legally, it is not tenable.
Correct.
In that event, your lordship will record my objection.
Lordship reserves the right.
No,
if she
the
wants,
lordship
wants
will
to raise an
record my
I
objection.
will record your objection and I will not allow to continue with the
My lord, it's done, my lord. It was only 2 questions, lordship. I am done with the
Those
re-examination.
questions could not have been asked at that
record
stage.
your objection because it has already come on record.
Yes.
I will
I am surprised nobody objected to it.
why-
Even my learned friend could not have asked. He knows the provisions very well, my lord.
No, I am not aware of whether the other crossing.
Yes, my lord. That was pending.
Actually, at that point, I just submitted that I shall examine, cross-examine.
Miss Mukherjee's junior was there, the advocate on record there. Nobody stood up, took this point. Today, my lord, this is
My lord,
not
this is a
possible
point
without an
which is a point of law, which is there on the statute.
Even then, an
It
application
is not required.
Mr. Court was
Suffering for the defendant number
cross-examining the witness at that point.
Full stop. The matter was listed on 23rd February
We are here to assist the court, not misguide the court.
23rd February 2024 for further cross-examination of the defendant witness number 1. Plaintiff witness,
Plaintiff's witness number 1.
witness number 1. And the counsel for the defendant number 1.
Yes, my lord.
Counsel for the defendant number 1 has completed the cross-examination. And after completion of the cross-examination on the plaintiff witness by the counsel for the defendant number 1, the counsel for the plaintiff has re-examined the cross-examination by the defendant number 1, by the counsel for the defendant number 1 to the plaintiff witness number 1. This PW1 cross-examination who has completed?
Defendant number 1 completed cross-examination.
No. Mr.
2
Kaur
to
was
4.
2 to that was 3 and 4A to 4C. 2 to
the completion of the cross-examination by the plaintiff's witness by the counsel for the defendant number 3,
4A to 4C.
3 and 4 series. 3 and 4 series, the learned counsel for the plaintiff had re-examined the witness by putting 2 questions. That is question number 908 and 909. And accordingly, the examination of the plaintiff witness number 1 was deferred. Today, when the case is called, counsel for the defendant number 1 raised objection and submitted that the defendant's
all the defendants have not completed
The stage of cross-examination is not over as yet.
all the defendants have not cross-examined the witness, and cross-examination of the plaintiff witness was not completed. But in the middle, the counsel for the plaintiff has re-examined the witness, which is not permissible under law, and prayed for expunging the questions, that is question number 908 and 909.
Kindly records my submission, my lord.
By the learned counsel for the plaintiff. Learned counsel for the plaintiff raised objection and submits that after completion of the cross examination, the learned counsel for the defendant number 3 and 4 series, in presence of all the learned advocates, the learned counsel for the plaintiff has re-examined the plaintiff witness.
And no objection was raised by any of them.
By putting 2 questions, and at the time of re-examination of the plaintiff witness, none of the advocate appearing before this court have raised any objection, and submits that at this stage the 2 questions cannot be expunged, as the same has already brought on record. Consider the submission made by the counsel for the respective parties. This court find that the witness was already been re-examined in presence of all the witnesses, and as such, it would not be proper for this court to expunge this cross-examination.
Re-examination.
To expunge this re-examination, being question number 908 and 909. With regard to admissibility of the re-examination is kept open at the time of filing. At the time of final.
I'm deeply obliged. My lord, while recording my objection, Your Lordship, I could not hear the entirety. I was relying on section 138 of the Evidence Act.
For the plaintiff and defendant number 1 raised objection in terms of section 138 of Evidence Act, and submitted that re-examination cannot be completed, cannot be done unless and until the examination of the cross-examination of the witness is completed.
I'm deeply obliged.
Yes.
May I please, Your Lordship? Mr. Witness, as you have deposed on 16 January 2023, that your name is Mr. Satish Vasudev Dhote. Is it correct? Your name is Satish.
My lord, that is correct.
In question number 1, you have answered. How are you connected with the suit? You have said you are one of the plaintiffs of the suit. Is it correct?
My lord, that is correct.
Mr. Dhote, you are deposing on behalf of yourself or all the plaintiffs, or on behalf of all the plaintiffs?
My lord, I am deposing on behalf of all the plaintiffs.
You have deposed in in question number 9 that the title of this property was conveyed to us in 2 separate deed of conveyance, and the same was conveyed in favor of the plaintiff in first half by Prithvish Chandra Saha and Neha Saha, and second half by court decree. Is it correct?
Yes, my lord, yes, that is correct.
Kindly come to the decree passed by the citizenal court. It is at page 204 of the judge's brief of document. This document is nothing but a court's record. Is it so?
Yes, my lord, it is a court record.
Mr. Dhote, kindly come to 5th line of the order. Have you come? By an indenture of agreement in writing of 8 May 1989, the defendant agreed to sell the present premises to the plaintiff for a consideration amount 12 lakhs. Is it correct?
Yes, my lord, that is correct.
So, 8 May 1989, there was an agreement as per your deposition. Is it so?
Yes, my lord, that is correct.
Was that agreement for the entire premises to sell?
Yes, my lord, it was for the entire premises to sell.
Kindly come to page number 205 of the judge's brief of document. Correct. 6th line. Plaintiff paid an advance of rupees 51,000 to the vendors. Is it for the consideration for entire premises? Advance, towards advance.
Can you repeat the question, sir? Is it for the
consideration for the entire about the advance?
My lord, there is a payment schedule in the agreement for sale. Can I refer to that document?
First, the question whether the 51,000 lakh, what a 51,000?
1,000
was the part amount of the total sale consideration. That is the question. That is your question?
My lord. My
The
lord.
51,000 is the part consideration or the full amount?
For the entire premises.
Yes, for the entire premises.
My lord, it was for the entire premises.
Kindly come to next line. At the time of execution of the agreement, it was further agreed by and between the plaintiffs and defendants that one of the defendants would act on behalf of the other vendors and would sign or, I'm sorry, extremely sorry. Agreed by and between the plaintiff and defendants that one of the defendant would act on behalf of the other vendors and would sign or accept money on behalf of his uncle, the defendant number 1.
Yes.
Particularly to that statement, was there any authorization letter on behalf of other vendors to the defendant number 1 here in the particular suit?
Last part, last part. Particularly to that statement, was there any authorization?
Is there any authorization was there or not?
My lord, there was an authorization from defendant number 1 to, may I use the names from Hitesh Chandra Shah to Pritesh Chandra Shah, and that has been submitted as one of the evidence. That letter of authorization has been submitted as one of the evidence.
Mr. Dhote, apart from that particular letter as you have deposed, was there any power of attorney given to him to execute the sell it or to accept money on behalf of other vendors?
My lord, the authorization letter was complete in I'll have to check the exact wordings, but
No,
it's
no, the specific question other than the authorization, is there any power of attorney or not?
my lord, not to my knowledge.
You have deposed in question number 17 that you have heard about Bharat Lithographing Company Private Limited. Is it so? You have just heard about the Bharat Lithography Company or anything else?
Where is the question? Give the question number 17.
17, my lord.
Take that book first. Book at all.
এখানে আছে। ওইটাতে আছে না? ওইটা, ওইটা। Okay. 70, পরে আছে।
My lord, the way the question was framed, have you heard of the company Bharat Lithographing Company Private Limited? And I answered, yes, I have heard. I'm not sure what to answer further for that. Yes, I have heard. That's still also currently my answer.
I have given the answer to the said question as it was put to me. Whether have you
Have you heard
about the lithography
company Bharat Lithographing Company Private Limited?
lithography company private limited? And I answered, yes, I heard about the same.
You have also deposed in answer to question number 20 and 21. Bharat Lithographing Company Private Limited was established in 1952 and was a tenant on the subject property. Is it correct?
My lord, that is correct.
Till date, that Bharat Lithographing Company is occupying the suit premises as a tenant.
My lord, that is correct.
Under whom he is tenant? That, sorry, not he, that Bharat Lithographing Company is tenant.
My lord, Bharat Lithographing Company has been historically a tenant under Kshitish Chandra Shah and Pritish Chandra Shah, historically. And currently we are tenants. Bharat Lithographing Company is tenants under the plaintiffs.
Since when Bharat Lithographing Company is a tenant under the plaintiffs?
My lord, Bharat Lithographing Company Private Limited is a tenant since 2000, is 50% tenant since 1992 and 100% tenant since 2009.
Is Bharat Lithographing Company has been implicated as party in the present suit?
No, my lord, no. Bharat Lithographing Company is not implicated as a party.
You have deposed in question number 23 that the company was a tenant under Jagdish Chandra Saha and Kshitish Chandra Saha, and they issued rent receipt. Is it so?
Yes, my lord. Historically, they've issued rent receipts to us.
Sir, this is the it has come on the cross-examination. Again, you are putting the cross-examination to the cross.
Because there are some infirmities. How much was the rent?
My lord, the rent was initially 900 plus 200 per month. When till before 1992, till we purchased the first half of the property. Subsequent to 1992, for few years, in the normal and usual course of business, we continued to pay, even though we were owners, we continued to pay the 900 plus 200 per month till about 1996. And then we started paying 450 plus 100 as the rental per month.
In answer to question number 30, you have deposed that the quantum of rent is 1900. Please look at the exhibit A, rent receipt of May 1979. Page 4 of the Judge's Brief of Document, volume 1. Rent receipt, exhibit A, receipt of May 1979. Page 4 of the Judge's Brief of Document, volume 1.
Volume 1 টা দেখো।
Uh,
না এটা 2 page 4 My lord, I don't find any reference to 1900. It's must be a typographical error. One must have come into play, so one has to be struck out. I don't
Whether
see.
you find any 1900?
No, my lord, I do not find any 1900.
Witness, after going through the page number 4 of the Judge's Brief of Document, volume 1 of the Judge's Brief of Document, and submitted that there is no amount mentioning as 1900, rupees 1900.
In question number 28, you have deposed that KRISHNA Saha issued rent receipt. But in answer to question number 23, you have deposed that both Jagadish Chandra Saha and KRISHNA Saha issued rent receipt. Which one is correct?
Sir, what are the two question numbers?
In answer to 28 and 23.
28 and 23. Achha, 23. In answer to one of the previous questions, you have deposed the correct. My lord, the question number 28 is linked to question number 27, which says a specific rent receipt was shown to me, and that document was issued by Kitish Chandra Shah. I stand by my answer. And in question 23, I am being asked, can you indicate under whom was the company a tenant? The company was a tenant under Jagadish Chandra Shah and Kshitish Chandra Shah. I still stand by my answer.
In answer to question number 80, 81, and 82. একশো সাত নম্বর 87 থেকে 102
79 মানে first question তো 80 হবে। What are the questions?
80, 81, 82. Page 87. Volume 1.
Yes, sir. What is your question?
You have deposed that page 87 to 8102 are rent receipt showing rent rupees 900 plus 200 for the period February 1993 to February 1994. So the company paid rent to the defendant for entire property.
Sir, in question 80, there is no mention of 900 as a number in question 80. You are referring to question 80, 81, 82.
Yes, I'm showing you document copies whereof you have been deposited at page number 87 to 102 of the judge's document. What are those documents about? These documents are the rent receipt. Question number 80, 80.
87, 102. 87 to 102. Okay, what is your question, sir?
Yes. So, yes. So the company paid rent to the defendant for the entire property. Is it correct or incorrect?
My lord, referring to page 87, the company paid rent for the entire property, which is 900, and that's receipt 681. And for receipt 682, the rent of rupees 200 was paid. Does that answer your question? Or no?
You have deposed page 87 to 102 are the rent receipts showing the rent rupees 900 plus 200 for the period from February 1993 to February 1994. 87 to 102 of the judge's view of document. November, no? Actually.
So what is the question, sir?
So the company paid rent to the defendant for entire property.
These all documents are connected with the rent of entire property. What is your answer on that?
Yes, sir. This document, this rental was paid for the entire property, full stop. As I have deposed in my previous answer, that in the normal and usual course of business, we continue to pay 100% of the full amount of 900 plus 200 in spite of owning 50% of the property in 1993.
We have also deposed in question number 111 that Bharat Lithographing Company Limited paid rent rupees 900 plus 200 up to January 1996. It is reflected at page 110 of judge's brief of document. You have disclosed.
What was the question number?
111.
Okay. I stand by the answer to question 111. And what is the next part of the question?
What is your question on that?
Yes. So you have paid the Bharat Lithographing Company paid the entire rent to the defendant for the entire property up to January 1996. Is it correct or wrong?
Sir, may I refer to the judge's brief? Volume 1 to 1. My lord, from in page 111, volume 1 of the judge's brief of documents, it is reflected that we started paying rent of 450 rupees plus 100 rupees from the receipt dated 1 February 1996 onwards.
I have asked you the in answer to question number 111, you have deposed. Question number 111.
What was the quantum of that? Sir, I stand by my answer. My lord, I stand by my answer. My answer is quantum of rent was rupees 900 plus 200. And I can repeat the question if required.
So you have paid, sorry.
Yes, yes.
So you have paid a sum of rupees 900 plus 200 as the rent for the entire premises to Sahas as they were the owner up to that period of which you have mentioned here. That is 1996. Is it correct?
No, my lord, that is incorrect.
Would you kindly tell my lord, then why Bharat Lithographing Company paid full amount of rent for the entire property?
My lord, Bharat Lithographing became the owners of the property in 1990, became the owners of undivided half portion of the property in 1992. Till that time, we were paying.
That's why asking simple question. He asked why you have paid the total amount till 1996. Simple question.
We paid. Um,
Why you have paid the total amount once you have become the owner of the half portion of the property?
it was an adherent slip of business normal and usual course of practice.
Are you authorized by the Bharat Lithographing Company to say so? This answer which just now you have said before this honorable court?
Have been authorized to
Yes,
say this?
my lord, I have been authorized.
Can you produce that authorization letter that Bharat Lithographing Company has authorized you to submit before this honorable court their version?
My lord,
Sir,
it's a verbal.
this will not go. It is a cross examination. Whether the authorization will go, only this answer may be given, this answer may be given. You have put your axe on your leg. He has given the answer in the cross. Whether the what is the cross examination, whether he will get an authorization.
Only
He the first person, he has been authorized to represent the plaintiffs.
He has been authorized by the plaintiff.
Correct.
But here he is deposing that Bharat Lithographing Company has paid the rent. But he is not Bharat Lithographing Company.
Put the suggestions.
So you are not deposing on behalf of the Bharat Lithographing Company.
My lord,
whether you are deposing on behalf of the lithography company or not.
My lord, I am deposing on behalf of Bharat Lithographing Company as well.
Then you have to produce the copy.
Authorization letter of
Authorization.
Whether the put the question record through court. Whether lithography company is the party to the suit.
No, my lord, is not a party to the suit.
Is the lithography company has given any authorization to depose before this court on behalf of the company here?
Not in a written sense.
See how much you will go, then the cross examination will not complete. Whatever the truth you have to say before this court. If you want to hide something, then it will going and going and going. It will not be finished. You know that the lithographing is not here in the party. Why you are studying all the things? Yes.
Kindly produce the exhibit X. Agreement.
First you hear the question, give yes or no. Then you give whatever you wanted to justification.
Uh, in answer to question number 183, 184, it বার করে দিন question. Questionটা kindly বার করে দিন। এখানে আছে, এখানে বার করে রাখো। 183 and 184, you have deposed that an agreement for sale was made on 8th May 1989. It is at page 170 to 178 of Judge's document. Exhibit.
That is the exhibit. That is exhibit.
Yes, my lord. That is exhibit
X.
O. Exhibit O.
Exhibit O.
Exhibit O, my lord. And you have said, yes, this is the agreement for sale which I have referred in my earlier answer. Is it so?
Page number?
My lord, page 170. 170 to 178 of the Judge's Bureau document.
Yes, sir.
Is it that agreement which you are referring?
Yes, my lord.
Can you find any reference about the agreement for sale dated 8th May 1989 in respect of the suit property in the sale lead dated 2nd May 1992 as you have deposed that was executed in the year of 1992 in respect of the half of the suit property?
একটু কোয়েশ্চেনটা পড়ে দেবেন স্যার।
That was executed in the year 1990 in respect of the half of the suit property.
My lord, no. There is no reference of the agreement for sale in the registered indenture
Registered indenture of which?
of
date?
first half of the property, May 1992. Of
First
first
property
half of the property in May
dated
1992.
Can you tell my lord that the agreement dated 8th May 1989, was it registered document or not?
My lord, it was not a registered document.
Can you come to that agreement for sale dated 8th May 1989? No, it
It is 8th day of 1990. It is.
Page 170 of the Judge's Bureau document.
Yeah, okay,
Yes.
I've got.
Can we come to page 176?
Yes, sir.
Can we come to the schedule of payments referred to?
Yes, sir.
First payment is rupees 51,000 and odd as an earnest money. Thereafter, 50,000 at the time of execution and registration of proper conveyance. Third, 1,50,000 by 31st December 1990. Fourth, 1,50,000 by 31st December 1991. Fourth, 1,50,000 by, sorry, see, yeah,
91. Yes, yes.
92, 93, up to, up to 94, you have pay, there is a schedule of payment referred to, that is up to 1994, you are required to pay 1,50,000 every year by 31st December, up to 1994. Thereafter, rupees 1 lakh by 31st December 1995. Thereafter, 50,000 by 31st December in the year of 1996. Thereafter 50,000 by 31st December 1997. Thereafter 50,000 by 31st December 1998. And then 50,000 by 2nd December 1999. And thereafter 49,000 by 31st December 2000. Total amount is 12 lakhs 1 rupees. Is it correct?
No, my lord, the second last line is still by 31st December. It's a typographical error. If you can see double quotation marks, it is all of them are by 31st December of respective years. Okay, so what is the question now?
Was that payment was made as per the said schedule?
My lord, the payments were made outside of the schedule also because the sellers wanted money in advance from us. So ahead of this schedule, we made payments and registered the first half of the property.
You have already deposed that there is no such reference with regard to the sale deed made in the year of 1992 in respect of the half portion of the suit property. There, you have not yet disclosed anything about such payment. Is it so?
So the list of payments is displayed in page 78 and page 77 of the judge's brief of documents. Over a period of time, payments have been made and they have been listed here on page 178 and 177.
Can you come to page 178?
Yes, sir.
As it is reflected in this receipt, that last payment as I did, that is 16 February 1990.
Yes, sir. Yeah, what about it?
So the schedule which has been referred in page 176, it is not the payment as per the said schedule.
What is the specific question, sir?
Malad,
What do you want to say?
Malad, I want to say the schedule of payment which has been referred.
That has not been made.
Not
as
been
per
made.
the schedule.
As per the schedule.
Put the direct question.
Yes.
His question is that the schedule which has been mentioned in paragraph page 76, 78, 70, whatever it may be, as per the schedule, you have not made the payment.
My lord, we made payments ahead of the schedule.
But yet I agreement I sell it about what? Sorry. Right. Kindly come to page 177.
177.
177.
Yes, sir.
Kindly see the right hand side. Kindly read it, please.
On the right hand side of page 177 of Judge's Brief of Documents, Volume 2, I see 3 signatures of the vendors. Serial number 1 is Pritish Chandra Shah. Strike that, please. Is Kshitish Chandra Shah, Kshitish, Kshitish Chandra, CH, Shah, Shaha, by the pen of Prithvish Chandra Shah, Pritishwish. Chandra is CH, Shah is Shaha. That's number 1. Number 2 is Prithvish Chandra Shah, same spelling as previous one. And number 3 is Nihar Shah, NIHARSHAHA.
Was Mr. Prithvish Chandra Saha was given any power of attorney on behalf of Mr. Kritish Chandra Saha to act and to sign this document?
My lord, there was a specific letter of authorization from Mr. Khitish Chandra Shah to Mr. Prithvish Chandra Shah to collect all monies and sign all documents relating to the sale of 98/4 SN Banerjee Road on behalf of Mr. Khitish Chandra Shah.
So there was no such power of attorney given by Mr. Kritish Chandra Saha to Prithvish Chandra Saha to sign this document.
Not to my lord, not to my knowledge.
It's a little. Can we come to page number 183, Exhibit P. Exhibit P. This document was disclosed by you. Is it correct?
My lord, this is correct.
Kindly come to page 183. I'm just reading the first portion. This indenture made this 2nd day of March 1992 between Srimati Nihar Saha, wife of late Jagadish Chandra Saha of 152 Raja Rajendra Lal Mitra Road, Police Station Beliaghata, Calcutta 7,10,000, and 2 Sri Prithvish Chandra Saha, son of late Jagadish Chandra Saha of 152 Raja Rajendra Lal Mitra Road, Police Station Beliaghata, Calcutta 7,10,000, hereinafter called the vendors. So, as per this document, these 3 persons were the vendors.
2 persons.
Sorry, 2 persons were the vendors. Is it correct?
Correct.
Persons are
Are the
Persons were
vendors.
the vendors. Vendors. Vendors.
Yes, correct. This is correct.
Can you find their signature in this particular document?
My lord, their signature, the vendors' signatures are on page 191 of volume 2 of the judge's brief of documents.
Are you aware of their signature, that this signature is a correct signature or it's a genuine signature of the vendors?
My lord, the witnesses were my legal advocate, Lalchand Chaudhary.
No, I have not said so.
The question is, these 3 signatures, is the
2
genuine one the
signatures.
person's their own signature?
My lord, I can't answer that question because I was not present there. My legal counsel was present and he can answer the question.
So you cannot identify their signature, that it is the signature of the vendors. Is it so?
Yes, my lord, yes. My legal counsel can answer the question more appropriately.
Volume put volume put. Yeah, lose. Mr. Dhute, kindly take the volume 4 of the judge's brief of document.
এটা তুলে নেবে এটাও তাহলে
অর্ডার তো কোথায় গেল? অর্ডারটা এইটাই কালকে মুডে রেখেছিলাম কালকের কোশ্চেন গুলো এইটা ঠিক আছে
Yes.
I'm sorry. Mr. Dhote, in answer to question number 840, sorry, 839, have you got it? On 2nd March 1992, half portion of the premises number 98/4, SN Banerjee Road was purchased by Dhotes. You have said yes.
Yes, sir. Yes, my lord.
Yes. Next question. When did you apply for mutation on the basis of the purchase? You answered. We applied for mutation to Kolkata Municipal Corporation somewhere in the year of 2010. Is it so?
Correct. My lord, correct.
Next question, 141. So after 18 years, you applied for mutation of your name. Am I correct? You have answered yes. Is it so?
My lord, that's correct.
The next question was put to you. That is, why is the inordinate delay? You answered. The inordinate delay was due to non-compliance of the ownership by Jagdish Chandra Saha for the second undivided portion, half portion of the property, which was thereafter executed through a specific performance order by the City Civil Court learned bench. Correct. Is it correct?
Yes, my lord, that is correct.
Yes.
Sir, already the question.
I'm coming there. The next question number.
Why are you repeating all these things?
Malad, I'm just, I will be putting some another question. Malad, that is, you filed a suit on 2nd June 1995 before the City Civil Court of Calcutta in respect of the balance half portion of the suit property as you have deposed in answer to question number 844. Is it so?
Yes, my lord, that is correct.
Yes. আজকের ডিপোজিশনটা এর পরের যে আগের দিনের যে বোর্ডের ডিপোজিশনটা এইটা
How much time you will take for
Well, another 10 minutes maximum.
the other matter is fixed at 3.
Oh, sorry, Matters.
With respect to the matter at 3, Lordship, I would have anyway requested Lordship to take it up at 3:15. Mr. Operating Room, we have requested Mr. Posh.
Kindly come to page 487 of the judge's behalf document.
Four 87.
87. This is the order number 10 passed by the learned City Civil Court in respect of the suit number 1871 of 1995, dated 17 September 1997. Probably.
19 September, sir.
19, oh, I see. 19 September 1997. So, can you read that order?
It is exhibited.
Yes, my lord, this is exhibited.
Why you want to read the witness? It is exhibited. You argue the matter. You want to put any question? You
My
can
lord,
put the question.
I kindly come to last portion of the order. Issue summons up to the substituted defendant in both the measure, fixing the matter on 27th August 1997 for বোঝা যাচ্ছে না লেখাটা হ্যাঁ
For something and appearance.
something and appearance. So on 27th 8 1997 it was adjourned, and thereafter on 27th August 1997 again issue summons in terms of the order dated fixing the matter on
This is the matter of record. You argue the matter. The
Another
document
thing,
is
Malad.
exhibited. What is the question? You come directly to the question.
আচ্ছা, পাবে। Oh, 99 না? Kindly come to page 499.
499.
Yes, it is order number serial 42 dated 12th May 2006.
Yes, sir.
Would you kindly tell my lord what is the order?
This is also exhibit document.
Document, order passed. Here, my lord, why I am showing it? Well, there is an order passed by the learned city civil court that the service report is to be produced.
Okay, you argue the matter. What the witness will say is not the. The document is exhibited. You can argue the matter.
Yes, my lord.
As regards service of the notice and substitute, there are several questions also put by the.
Yes, no, my lord, what has happened before the city civil court? Their application for substitute, I mean, service that was rejected. Thereafter, they are directed to submit.
This is argument, and my lord, this is not correct. The records of the city civil court proceeding would show otherwise.
That is a matter of record.
It's a matter of argument.
Question number 847 to 847.
847.
Question number 847. 847. 8. In answer to question number 847, the question was, you did not apply for substitution in the suit. You answered, substitution was applied for and is recorded in the judicial document at page 500 as service of summons has been granted. Kindly come to page 500. Kindly prove your answer in here. You have said at page 500, the service has been granted. Service of summons has been granted. How it was granted?
My lord, I may have used the word granted, whereas it is service is accepted. That is the word that is used. I may have used the word granted. Do you want me to read the whole thing, sir?
Yes.
Okay. Petitioner, okay, this is order 46 on page 500 of the judge's brief of documents, volume 4, dated 26 February 26/02/2007. Petitioner files postal receipt. Full stop. Summons not yet returned. Full stop. In view of the above, service of summons XX, something is there, I can't make out, of defendant, service of summons XX, service of summons to defendant number 1, number 1, 2, TO 3, is accepted under the provisions of Order 5, Rule 9, bracket 5 of CPC. That should answer your question, or do you want me to read the
And
rest?
next, yes,
Okay.
read the entire.
Defendant number 1, 2, 3 do not appear today. Let the record be placed before the learned judge. Bench 9 on 6307 for order.
So for orders, it was put on 6/3/2007.
Okay, let it be complete. Let it complete.
Sorry.
You completed?
So there are 3 words I can't make out. XXX, XXX, XXX.
Witness could not identify the word in the said order. Yes.
But it is understood that the matter was placed.
Sir, plus let it be complete the answer.
Sorry, I'm sorry.
Then you put the question.
Okay, I'm done, sir.
You're done? Yes.
Thank you.
What is your next question?
So from the order, it is understood on 6 March 2007 that was placed for orders.
My lord, yes, that's correct.
So as you have said, the service of summons upon the defendant was accepted. That is not correct.
My lord,
agreed or not?
No, I don't agree. It is clearly recorded and mentioned that the service of summons to defendant number 1, 2, 3 is accepted. I don't understand.
Yes, next.
প্লেনটা একটু বার করো, প্লেনটা ওই এই যে একটু প্লেনটা দেবেন। Kindly have a look to the plane. I'm sorry, extremely sorry. Another 5 minutes. Another 5 minutes. I shall finish it today. That's right. Kindly come to paragraph 2 of the plaint. It has been stated, one Bharat Lithography Company Private Limited was at all material times a tenant in respect of the subject premises. The said Bharat Lithography Company Private Limited is a family company of Dhotes, exclusively owned and managed and controlled by the plaintiff number 1 to 6. Yes.
What is your question on that?
Well, I'm putting the question here. Well, I'm just kindly come to last portion of the paragraph 2, next page. I'm just reading from paragraph line 4th line. This apart, the said Bharat Lithography Company Private Limited has been from time to time making payment of rent to the owners of the subject premises, having paid rent to Shahars, Lordships kindly noted, being the erstwhile owners of the subject premises till about February 1992, and thereafter to the Dhotes, being the present owner thereof. Copies of the sample rent receipt issued by the Shahas in favor of the Bharat Lithography Company Private Limited as annexure marked as collectively annexure B. So the rent was paid to Shahas as per the statement of the plaintiff February 1992 and thereafter to Dhotes. Can you produce any receipt that Bharat Lithography Company after February 1992 was paying rent to Dhotes?
Yes, my lord. If required, we can present.
So you did not disclose any document till date. So far the rent paid by Bharat Lithographing Company to Dhotes.
My lord, I've stated in my previous answer that during the years 1992 to 1996,
Whether you have disclosed this document or not, simple question.
my lord, this document has not been disclosed.
That's all.
Where is? Can you tell my lord, presently, who is in occupation of the suit property?
My lord, Bharat Lithographing Company Private Limited is in occupation of the present occupation of the property.
Apart from Bharat Lithographing Company, was there any tenant in the suit property?
My lord, at one point in time, now,
Yes.
no,
Now.
now there are no other tenants in the subject property.
Before instituting the instant suit, was there any other tenant apart from Bharat Lithographing Company Limited?
No, my lord, there was no other tenant prior to this suit.
Can you tell my lord up to which period the other tenant were in occupation of the suit premises?
My lord, I don't remember the date.
That's all, my lord.
That's all.
My lord, one prayer I have. Now that, my lord, the defendant number one, all the defendants are there. Lordship had in the, my lord, first portion of that order recorded that subject to, my lord, the question of admissibility on the two questions put in re-examination. Now, if, my lord, at the final stage, it is, my lord, argued and it is held against my client, then my right of re-examination of those two questions goes. My lord, is it my lord's pleasure that as abundant caution without prejudice, I put on re-examination those two questions once again?
No, already there.
No, my lord, if it is, my lord, ultimately expunged, or lordship ultimately holds that it is not admissible, then, my lord, it would, my lord, prejudice my client's interest because I am not today doing the re-examination. So, my lord, I
And
want.
you can put the. So this court cannot advise you at this.
No, my lord, I was only, my lord.
Huh?
My lord, I only want your lordship to record that I made this prayer at this juncture once again. Kindly record that so that I can rely on this when I am arguing, my lord, finally.
So,
In that case, my lord will kindly record my objection to that prayer.
I will record. So cross-examination complete.
Yes, yes, cross-examination
you will be
complete.
adducing
Second
anyone?
witness, my lord. Anytime, my lord, in the month of March, if lordship keeps it.
So appearing for the printing. That has been recorded. Yes, please step down.
Thank you, sir.
Plaintiff witness number one is present and cross-examination is completed by all the defendants. Full stop. This court in the above, this court has kept the admissibility of the question put by the counsel for the plaintiff to the plaintiff witness on re-examination on 23rd February 2024, being question number 908 and 909, abeyance till the abeyance as the same is to be decided at the final argument, and accordingly the learned counsel for the plaintiff press for further re-examination of the witness
Without prejudice, my lord.
without prejudice to the right and contention of the defendant. But this court find that defendant counsel for the defendants raise objection for re-examination as the plaintiff has already put the question on the earlier occasion, and that has been recorded. Consider the submission made by the counsel for the respective parties. This court already the re-examination of the witness has already
এটা আমি
been
অবজেক্ট
done
করতে
on
পারবো না
23rd
কোন স্টেজে হবে সেটা
February
হচ্ছে
2026
being question number 908 and 909, and as such, it is, allowing the plaintiff further re-examine the witness will not, and as such, this court is not inclined to allow the plaintiff to further re-examine the witness. And with regard to the examination, then will be decided, the admissibility of the said question will be decided at the time of argument.
My lord, may I make a small submission? My lord, so far as the prayer for re-examination, my lord, I cannot object to that. Because after completion of the cross-examination, he is
No,
entitled.
he wanted to cross-examine the same question. You will allow them.
Same question. That is why I said, my lord, it can be expunged and he can put those questions fresh.
I can put him 2 questions that can be.
Those
And I will
same questions,
explain
but
that.
that
If you are ready, then I will explain
yes,
that.
my lord, I
question and
cannot
that-
object to his re-examination.
Because you, on the earlier occasion, you stated that no, you cannot be allowed to that question.
I don't
again.
know about the other defendants also. She is
Stage,
only
my
my lord
lord.
representing
Because
defendant
of
number
the
1.
stage, because the act provides that re-examination is allowed only after closure of the
That's
cross-examination.
correct. That's why I misstated
That
to you.
is,
Because on
I
the, on
objected
the
on
last
that.
occasion, nobody has raised objection. It was recorded. Now today wanted to cross-examine. You raised the objection. Now you recorded. Now you wanted that to
Well,
be taken
it
as
is his matter of right. If he wants,
Then allow me to
I
put
will
2
not.
questions, my lord.
Then I will explain that.
Yes, my lord.
Lordship
That is
expunges
what
that,
my prayer was.
I'll put him 2
Lordship
questions.
will expunge
Both
that and
order
allow him to. And another thing, my lord, if your lordship recollects, my lord, on the last occasion, last occasion when I was cross-examining the witness, I had called upon him to produce the certified copy of the original certified copy of the deed which was annexed to the plaint. My lord, he said that he will come up on the next occasion. My lord, today he is being discharged. So he has not tendered that. Let that be recorded that he has failed to.
Then I will record subsequent. Let him cross.
Yes. Please step into the box.
He has taken some order.
But we'll save 1 hour's time when we are arguing the matter because of this.
Then I record this. Okay, I will.
Shown questions 279 and 850 and the answers thereto. 279 and 850 and the answers thereto. Please clarify your stand as to whether
Yes, sir. Yes.
Please clarify your stand as to whether the decree passed by the learned City Civil Court at Calcutta that you were referring to, comma, was passed against a dead man or the heirs of the dead man.
My lord, it was passed against the heirs of the dead man.
That is all, my lord.
My lord, I want to cross-examine on
Cross-examination by the defendant number 1.
Mr. Dhote, have you anywhere in the plaint stated that the decree was passed against the heirs of the dead man?
My lord, the decree itself states that. So I did not have any
Again, you are putting, first you stated yes or not, then you can clarify that.
First answer the question,
First
then
answer
clarify.
yes or not.
My lord, no, full stop. The decree itself states that the order was passed against defendant number 1 and or his nominees.
I think that's
Grateful, my lord.
My lord, the
My lord,
dates have to be
dates have to be fixed, my lord, for further.
How many witnesses?
2 more. I
But
would
every
be. I
day
wanted to
is,
do one. I wanted to do one on commission, but Ms. Mukherjee possibly would raise an objection, so I indicate 2 more. March, my lord, any day, my lord.
March, I don't think.
April.
My client is suffering, my lord. Your lordship.
No, we are also suffering. I am the
My
plaintiff.
client
She
is
says
suffering.
her client is suffering.
Plaintiff is not suffering.
He is not suffering, my lord. They are not interested to proceed with the suit. Your lordship will see when
My
the
lord keeps
suit
it
was
tomorrow.
filed.
My lord keeps the witness action tomorrow. Let us see, my lord, who is interested and who is not.
Yes, my lord.
Come, madam.
কাল আসবে তো তোর lordship, if your
একদম।
lordship has a slot tomorrow, I am okay.
I have no slot. That's why no slot is in April.
কেন তোর তো কালকে হয়েছে ক্যান্সেল হয়েছে তো 20
না
The
দুটোটা তো
defendant witness is present.
তাহলে
Cross
এটা করে
examination resume.
কালকে করবি
Resume and concluded by all the defendants.
এই যে রাজস্বী
So the plaintiff has
29
also
তারিখের পরে আমাদের বসতে হবে।
examined the witness
চারটে
and
এটা
the
যেটা
counsel
আসবে
for
ওটা
the
কবে
defendant
বসবে আমি
has
জানি না
also cross-examined the witness after the
আমি একটু তৈরি হয়ে তারপর তোমার সাথে
তোকে কি সব
examination of the
দিয়েছে
plaintiff witness number 1 is closed. Counsel for the plaintiff submitted, he will adduce further evidence. Let the matter appear on 12th March at 2 p.m.
কবে
my lord one more day my lord
কবে
3:45.
I'll take it my lord 12th and 13th I'll take it
No, 13, 3:45.
very well I'll take it my lord not always my lord we have the pleasure of 3:30
3:45 is not a very my lord
Witness
the
action, because I
difficulty
even want the witness should be harassed.
and if the matter is not taken up again we'll have to come and
so
mention the matter
3:45 my lord if there is a resolution we know in the morning we'll ask witness not to come
What is that? 12th and another date is there.
3:45 ছাড়া অন্য কোনো
But in what time? 12th March 2 p.m. and 14th March at 3 p.m.
deeply
available আছে
বাবা ও কি করবে ও তো আসবেই
इंटरव्यू को बोलो कुछ टाइप मत करो, मेरा पास हम उसका करेक्शन
grateful my lord
deeply obliged your lordship
appear for the plaintiff, the
Yes,
Mm.
very sorry for that.
I have utilized your time to the other case.
I am so grateful to my lord for that. This is a rejection of plain, my lordship. I had covered the first point, that is the plaintiff's immediate lessee is the defendant number 1, and I am his sub-lessees. He has not asked for a decree for eviction against defendant number 1, and he has asked for eviction against the sub-lessee. That is the plaint prayers.
You are for the defendant number?
I am for some of the sub-lessees, defendant numbers. 2 and 4. And relief's claim, lordship will find at page 23.
2 and 4 you are appearing.
2 and 4. 2 to 5 are the occupiers of the property who are inducted by the defendant number 1.
Yes.
Lordship, that is their case at paragraph 7 of the plaint, page 17. Page 17. Page 17, paragraph 7. The defendant numbers 2 to 5 above named are in physical possession of various portions of southern side comprising of total area and alleges to be inducted by defendant number 1. Now, defendant number 1 is the lessee whose lease has expired according to them by a flux of time. Lordship will find from paragraph 15. Paragraph 15, page 19, page 19.
2015.
15. After, and paragraph 60, after expiry of lease and obligation to vacate. They have not asked for decree for recovery of possession from the defendant number 1, but are seeking to evict the defendant numbers 2 to 5, saying that they have become trespassers. So that is page 20. That is page 20, paragraph 17. First defendant on and from has no right, title, or interest. page 20. The first defendant honored from 1st October has no right, title, and interest in any manner whatsoever property. The plaintiff states that the defendant numbers 2 to 5 are in wrongful possession and has no right to remain in possession. And paragraph 20 are trespassers. So my lessor's lease has expired, so I've become, so his license has gone, so I have become a trespasser. The law requires, which I had shown 67 Supreme Court, if a lessee lordship has granted decree, expiry of lease, but not vacating, one has to get a decree for eviction, and automatically, and maybe all the other persons under him would thereafter get evicted. There is neither privity of estate nor privity of contract so far as the owner and the sublessees are concerned. That is 67 Supreme Court, which I had placed. 67 Supreme Court, page 67 Supreme Court, 1853. Yes, 1853, paragraph 7. Just the one line, just since there's a time gap. Paragraph 7, 67 Supreme Court, Hiralal Vallabh Ram.
Yes.
Paragraph 7. There is another aspect of the matter which equally affects the jurisdiction of the appellate court and which also does not seem to have been urged in the High Court. We have already indicated that there is nothing to show that the appellate court judgment that it ordered the ejectment of the tenants in chief. If it does not do so, it could not, in a suit brought by the landlord, order the ejectment of the subtenant, which the present appellant had been held to be the trial court. It is not disputed that a landlord cannot sue a subtenant alone for eviction. He has to sue the tenant, and if he succeeds against the tenant, the subtenant would be ejected along with the tenant in chief, unless he can take advantage of the provisions of the Act. Like Premises Tenancy Act, if a notice is given by the sublessee when the Act came into force and it is accepted by the landlord, then he has the direct right. But that is not the case. This is Transfer of Property Act. So the suit is misconceived because here the eviction is expressly prayed for, page 23 of the only against defendant numbers 225.
Yes.
Page 23. So that is their first prayer. No decree has been asked for against defendant number 1. Now I come to another aspect.
Yes.
Another aspect, Lordship. Lordship, also in this context, kindly just see one thing, my Lord. Paragraph 10 of the plaint, page 17.
Yes.
Kindly see, refers to the lease between the plaintiff and the defendant number 1, and the lease deed is at page
68. 68.
Yes, page 35. Lordship, can you see page 56? 56, clause 10. Here it was a lease with the right to sublet.
Yes.
The lessee shall not be entitled to assign the said premises as a whole or a part thereof until the construction of the new building as hereinbefore recited. Provided, however, the lessee have the right to let out the new building to be constructed or any part thereof during the construction and thereafter in such manner as the lessee thinks fit and proper. So the right of subletting is expressly given to the defendant number 1. Of course, nothing turns on it because on the rejection of plea, nothing turns on it.
Yes.
Now, Lordship, I am coming to another aspect. this lease is on the face of it a void lease, because on the date when the lease is given, my mistake, my lord, when the defendant number one gives the property to the defendant
Trustees give it to
trustees give it to the plaintiff, sorry, to the plaintiff, 2001, 31st March 2001. We were in possession of the property. 225 and other subtenants were in possession. As per the law, the law has been declared by several courts. When the property is in the possession of tenants, another lease cannot be created over the existing rights, over the existing rights of occupant. You can sell the property. If there are existing people in 2001 who were there in the property, then it cannot be created. Lordship kindly sees page 18 of the plaint first, paragraph 13. The trustees give it to the plaintiff. Paragraph 13, page 18. Pursuant, page 18. This is the averment in the plaint. I will show that first.
Yes.
Paragraph 13. Pursuant to and in terms of the leave granted by this Honorable Court by the order dated 19 December 2000, the trustees of the said trust executed in favor of the plaintiff on 31st March 2001 a lease in respect to the suit property, inter alia being the southern side of so and so, situated within the jurisdiction of the order. Now, Lordship, paragraph 14, the indenture of lease dated 31st March 2001 between the trustees of the said trust and the plaintiff was for a period of 50 years, commencing from 1st October 2015. So, but I am only on these two paragraphs. In the year 2001, lease is granted. At the time, defendant number one was a lessee still. There were persons in possession. Even though it's made prospective, it is never said vacant possession is available. Lordship kindly comes to page 68. This is the deed of lease by the plaintiff to the Malliks, trustees to the plaintiff. Malliks is particular, Malliks. Defend number 6 onwards, I think. Malliks are the defend number 6 to 10 gave. Now, Lordship kindly comes to the lease of page 68.
Yes.
Kindly come to page 70. Recital A.
Yes.
The lessors are well and sufficiently entitled to all that premises number so and 50 Chaurangi Road, hereafter called the said premise, subject to the subsisting lease in favor of Orient Beverages Limited, granted under indenture of lease of 29 September 1965. Lease is to expire 30th September 1965. And Lordship, I had shown the lease deed between the defendants, between the Malliks and the defendant number one, which gave a right to sublet also. And we are admittedly, we were inducted into the property amongst others. Now, whether this lease is a valid lease, or 6-1 CHN. The judgment which I want to first place is Khaitan Consultants' judgment, reported in 2006, volume 1, Calcutta High Court Notes, page 12. Así que yo কিংবা হয়ে গেলে দেখি একটাই আছে
Only I'm putting my learned friend on notice. This has been set aside. But it's been set aside. This judgment. I would have. maybe for different reasons.
Different reason. Of course, I know that.
It's set aside.
Of course, I know
And the
that.
appeal is being heard again.
I know
So
that.
this doesn't
That's
exist.
on a different.
I don't know. If my learned friend feels it's fine to say, I can give the Supreme Court.
Paragraphs 11 to 14. Not on this point, of course.
It doesn't exist. The appeal is
Anyway,
being
I will
heard
show other judgments relying upon this. So let me show the law here.
This judgment has relied on other judgments. My learned friend can rely on those, but can he rely on this decision? That's
Yes, Mr.
Yes.
Mitra, if
Not
it
you-
is
Huh?
set aside,
6. শম্ভুনাথ মিত্র বসে খেতেন কনসালটেন্ট
Sambhunath.
কিন্তু দেখাচ্ছ খেতেন
Now you have shown the single bench judgment, then this is a division bench judgment.
ও মানে
Earlier you have given this single bench judgment.
আমার 6-1 তুমি এটাকে দিলে কেন?
No, that is also how it is.
এটা তো ভাষ্য করছে যে
হুম
No, 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 no.
ও লর্ডশিপ
No, that is
6-1 sorry 6-1 CHN it is Sukumar Shah lordship.
Sukumar Shah, yes, Sukumar Shah.
Sukumar Shah.
Yes, you have given this.
I
Sukumar
have
Shah
given
has
yes.
given.
Lordship. That was my junior first day. I was not there, so he had handed up all the GR handed up judgments.
But you are not relying upon this. Ketan's consultant.
5-2 CHN. No, that I am not relying upon. That I am not relying.
5 to section you are not relying upon.
What is that? 6-1 CHN page 12.
Yes, 6-1. Yes.
দাও না ওরে আমার দুখানে দিলে কেন একটা আছে তো সামনে আমার আছে
That is the paragraph 12.
paragraph 12.
Yes, you are relied upon.
After hearing the parties and after going through the view that lawful tenancy can be created in favor of a person by a lesser only if the lesser is capable of giving khas possession of the tenanted portion in favor of the lessee. If a particular property is the occupation of a trespasser, without evicting such trespasser, the lessor cannot create a lease over the portion so occupied. Lease is a doctrine of separation of title and possession. A lessor, before grant of a lease, enjoys the title over the property as well as the right to immediate possession thereof. The moment such a lessor creates a lease, the title remains with him, but the right to enjoy the property is transferred to the lessee, and he is not entitled to enjoy possession thereof by himself so long the lease continues. Therefore, no tenancy can be lawfully created by a lessor unless he is in a position to deliver actual physical possession of the property in favor of the tenant. In this case, according to the plaintiff, Honorable Kumar Shah, so and so. And then paragraph
14, 13.
Paragraph 13.
And 14.
Such being the possession, no lawful tenancy was created in favor of the plaintiff in respect of the property. Once it is held that by virtue of tenancy granted by defendant numbers 2 and 3, plaintiff became tenant only in respect of the property which was in his actual possession. By dint of such rights, he cannot file a suit for eviction of a trespasser for recovery of possession over which his tenancy does not exist. So I'm on this.
So you mean to say the original agreement entered between the trust and the plaintiff, it is not valid.
It's invalid so far as the portions of the property which were in the possession of my client and somebody else. So that is void. So far on the basis of this deed of the year 2000, he cannot sue for my eviction because this does not give him any right whatsoever.
Okay.
This is 6. Ever the 14 to CHN now. The next judgment on this proposition, though this is a division bench, so it will be is 2014 to Calcutta High Court Notes, page 437. Paragraph 9.
Yes.
Having heard the learned counsel appearing by respective parties and after considering the impugned judgment and decree, we are of the view that a lawful tenancy can be created in favor of a person by a landlord only in the event the landlord is capable of giving khas possession of the tenanted portion in favor of the tenant. It is well settled principle of law that in the event of a particular property is in possession of a trespasser, without evicting such trespasser, the landlord cannot create a tenancy in respect of the same portion of the property. So occupied, in other words, no tenancy can be lawfully created by a landlord unless he is in a position to deliver actual physical possession. Reference may be made to the decision of Shukumar Shah, and the relevant portion of the above decision are quoted below. Now, this is the quotation. In the suit, then paragraph 10, in the suit, though the appellants claimed their lawful tenancy over the suit premises on the strength of the rentries, well, that is factual. That's not. I want those 16 to those 16. Jyotirmoy. Da. Can you give me 1 minute? No, that is really Ashira. But these two division bench judgments are for the proposition that he has no locus standi. Okay. These are my 2 points on which, and my last submission, their case may be that the lease was granted as per leave of court. As per leave granted by the Honorable High Court. This is the lease which they have executed in pursuance of a leave granted by the Honorable Court. But when leave is granted by the court, leave is granted always to do it in accordance with law. So I gave you leave to file a suit. That suit is not a good suit unless it is done in accordance with law. Because that is their averment. I am apprehending this kind of a submission. Because page 10.5 SCC. Yes. Paragraph 12, they have said that the High Court granted leave to the trustees to execute the lease. Paragraph 12, page 18. Page 18 of the plain.
Paragraph 12.
Paragraph 12.
Yes.
On an application filed by the trustees of the trust before this.
Pursuant to the leave granted.
Yes, leave granted. So, leave granted to execute does not mean whatever they execute will be valid in law. So that whatever is executed will have to be seen whether it's in accordance with law or not. So it would have presumed that if the trustees had to grant leave, they would have, with this leave, they would have had to first throw out the persons in occupation and then grant the lease. This does not make the lease deed valid, which is otherwise invalid in law.
Yes.
Lordship, that is why I'm just placing one paragraph from liberty to file proceedings. It is 2010-5 SCC 213. In the context of liberty to further litigate. Paragraph 41, page 223.
Yes.
Paragraph 41. Instances abound where observations of the court reserving liberty to the litigant to further litigate have been misused by litigants to pursue remedies which were wholly barred by time, or to revive stale claims, or create rights or remedies which there were none. It is needless to say that courts should take care to ensure that reservation of liberty is made only when it is necessary. Such reservation should always be subject to remedy being available in law, and subject to remedy being sought in accordance with. So this does not make it any more valid than it is otherwise. But that is all I have to say.
Thank you.
Bolo.
My lord has also kept it at 3 tomorrow. I can start.
It's tomorrow.
Will you take up the full of tomorrow?
Kal bhi fix hai.
Take up the
Kal bhi hai.
you'll take up tomorrow because Lordship, I'll have to tomorrow after he finishes. I will not be. I'll have to leave for somewhere. So in case he finishes tomorrow, in case I will just
Deal
take.
with the 5 judgments. I think I'll take.
I'm
Your
good.
lordship has another matter at 3:45 tomorrow also. So I'll be.
Consistent suffering for the plaintiff, consistent suffering for the defendant. Defendant has filed the present application with 5 of 2022, praying for rejection of the plaint. Counsel for the defendant has concluded his argument. Counsel for the plaintiff, and due to paucity of time, counsel for the plaintiff start the argument. The matter is already fixed tomorrow at 3 p.m. Yes, next.
Lordship, I appear for the plaintiff. This is my suit, Lordship. It is fixed for argument. It's an undefended suit. On 18th of January, witness action was concluded, Lordship. There are certain minor corrections, Lordship. Before starting, shall I do or shall I hand over the corrections?
Which may? In the deposition?
Lordship, in the deposition.
Inform my officer.
Lordship, I have made necessary corrections. I am handing over. To dekhe na deposition. Lordship, it's a money suit. My claim is arising out of non-payment of balance rental charges for the capital equipment given on rent. Lordship would take the plaint, Lordship. 4 work orders have been issued, which is Lordship Exhibit B. It starts from page 16. Defendant has issued 4 work orders in favor of plaintiff for supply of capital equipment on rent between June 2011 to February 2012. In terms of those work order, Lordship, I have supplied capital equipment on rent and I have raised bills. Your Lordship would see all the bills which has been marked as Exhibit C from page number 27 onwards. Page 27 to 104, Exhibit C. If your Lordship would take page number 26 of my plaint, it consists of details of the invoices raised, which is amounting to rupees 65,61,837.
Yes.
So out of this amount, Lordship, there were some credit notes issued, and adjusting the credit notes, the total bill stood for a sum of rupees 57,89,159, which I have stated in paragraph 7 of my plaint. Lordship would kindly take paragraph 7 of my plaint. Paragraph 7, page 4. Lordship, I am reading this. In terms of the aforesaid 4 work orders, the plaintiff has given on rent capital equipment upon the defendant and has duly raised its bills and invoices for a total sum of rupees 65 lakhs and odd. The plaintiff has issued some credit notes, and upon adjusting the credit notes, the net amount payable by the defendant to the plaintiff for the total bills raised is rupees 57,89,159. The Lordship would kindly come to paragraph 9, the next page.
Yes.
In admission and acknowledgement of its liability and indebtedness to the plaintiff, the defendant has released part payment for a sum of rupees 42,04,457. The defendant has made last payment to the plaintiff by issuing a NEFT being number so and so, dated 6th February 2013, for a sum of rupees 1,50,000. thereby leaving a balanced principal amount of rupees 1584,702. This is the only principal amount I am claiming before this court, Lordship. Now, Lordship would kindly take Exhibit D, which is page 105. Lordship, page 105 is the Kotak Mahindra bank statement from February 2013, Lordship. Kindly come to page 107. There is an entry, Lordship, at 75. I have received 1,50,000 on 6 February 2013.
Where it is? Page number?
Page number 107.
Okay, 1 lakh. 1,50,000.
Lordship, this is the last payment I have received. Thereafter, Lordship would kindly take Exhibit E, the next page, which is 108, 109 and 110, which is very, very important. From this, I will show Lordship the limitation period also.
So
Page
what is the
100
last payment of the 2013?
2013. But thereafter, there is an email, Lordship.
6 February 2013.
Lordship.
When you file the suit?
Lordship, I have filed on 18th of February 2016. There is an email by them on 19th February admitting this amount. Lordship, I shall take your Lordship to that email. Lordship, kindly come to page 108 of my plaint. This is Exhibit E, Lordship. I am reading. Lordship, this is Mr. Nandan Vardak from plaintiff is writing to Gemini defendant on 19th February 2013. Dear Maniraj, your Lordship has got that?
Yes.
Dear Maniraj, please confirm outstanding balance for Kalinagar site ASAP as early as possible. Lordship would kindly come to the next page, 109, which is very, very important, Lordship. This is an email again on 19 February 2013 by Maniraj on behalf of Chitra Builders, writing to Nandan Vardak, Gemini. Lordship would see, please find the below reconciliation and arrange to correct your books accordingly. The detailed accounts, ledgers of both of us are enclosed herewith for your reconciliation. On the left-hand side, Lordship would see balance outstanding 1584,702. Lordship have got this, page 109.
Yes.
So, Lordship, by this email, they admit that
So this email was sent by whom?
by Maniraj Chitra Builders. Lordship will see Maniraj Chitra Builders
Okay, from, yes.
to plaintiff.
Nandan Vatrak.
Lordship.
This
In
is of-
page 108, Lordship, I have asked for confirmation. By 109 page, they are admitting this is the amount due. Lordship would kindly take 110. This is an email by the witness who has deposed Lordship Mr. Satish Pujari on 21st February saying that this is reference to below mail. We hereby confirm outstanding payment to Gemini from Chitra Builders rupees 1584,702.
Correct.
So, Lordship, this was this email. The page 109 is dated 19th February 2013. The suit was filed on 18th February. Lordship, I have also obtained a report, the status report, which says, Lordship, I have marked 18th February. The suit was registered, Lordship. It was filed. I have got the number on 18th February. So it is within a period of 3 years.
Date of registration 18th February.
18th February 2016.
Okay.
It has been affirmed, Lordship. So I am within limitation period. If your Lordship would kindly come to the next annexure, which is the demand notice, Lordship would kindly come to page 113, which is Exhibit F, Lordship. It is a demand notice. The demand notice, the next page 115 is the postal receipt, and 116, Lordship, the envelope has returned with the endorsement. Lordship would see page 115. It says room number 405, receiver refused, addressee moved. So it is a good service, Lordship. This originals have been lost. So there is an FIR that has been lodged. If your Lordship would take my judge's brief of document, page number 112 to 114, Exhibit G, Lordship, an FIR has been lodged by the witness who has deposed Mr. Satish Pujari, page 112 to 114, regarding loss of this demand notice, Lordship. Lordship would kindly take that judge's brief of document, page 107 to 111. Lordship, it is Exhibit H. Lordship, I have also instituted a winding up proceedings, Lordship, for winding up of this company, and an order was passed by Honorable Justice Vishwanath Shamandur directing the company to pay this amount. but they did not pay, Lordship, and thereafter no steps were taken by the plaintiff for advertise. Lordship would kindly take page 110 of the judge's
What is the order dated?
Order date is 15th March 2016. This was prior to my institution of
So prior to the institution, you filed a company suit.
Lordship.
Company of
Lordship. But
petition.
this is not an alternative remedy. It's a separate proceeding for winding up
What
of
is
the
the order
company.
in that? Admitted the principal.
Lordship, I am reading page 110.
After this order also they are not paid.
They did not pay, and I have also not taken any steps for advertisement. And your Lordship knows after insolvency and insolvency and bankruptcy court, the cases has to be transferred before NCLT. That was also not done. So in my most respectful, humble submission, there is no bar by this court to pass an order because it is a recovery proceedings. It's a money suit, and it can be filed even if my binding a petition is pending. But in the instant case, it is not pending, Lordship. No steps have been taken. In other words, that has been abated because, Lordship. So, Lordship, may I take your Lordship to the deposition, the relevant deposition, Lordship? Lordship, I am just one paragraph, Lordship, where I am claiming this amount. Lordship, page 9, paragraph 16. Page 9, paragraph 16, Lordship. Lordship, total principal amount
15 lakh plus interest.
plus interest, Lordship. So 21 lakh 55,000 till the date of filing of this petition. Thereafter also, Lordship, I am seeking.
I will take. So offering for the plaintiff. Argument concluded. Fixed for judgment. CAV. What about the service you mentioned? That
Lordship, defendant did not appear. There was writ of service. Yes, Lordship. So we have gone for substituted service. There was an advertisement in the newspaper, Statesman and Lordship Bortuman.
Okay,
got it. I shall show you, Lordship.
Got this.
Lordship.
CAV.
I am deeply obliged, grateful, Lordship.
Well, I appeal for the defendant.
I appear for the plaintiff. The inspection has been completed. Now, I have brought my issues. The thing is, what I want to point out is that they have relied upon 3 documents, although they have not filed their affidavit of documents. So those 3 documents we have also relied upon. So it's admitted. So there is no question of my filing any affidavit of denial and dispute, admission and denial. So your Lordship may frame the issues.
Well, there are 2 issues
And,
that I want.
and my Lord, they have not filed any admission or denial. So that stage is over. Then now let kindly frame the issues and proceed with this.
My lord, on Friday the exercise of taking inspection was concluded. Now, my lord, on Saturday, my lord, my end of the suggested issues, my lord, I've shared. I have not received, my lord, the plaintiff's suggested issues as on date.
The admission and denial.
Now, my lord, the admission and denial, Friday, my lord, I've taken inspection of those
The
documents.
2 minutes.
No, my lord, I'll tell you,
Too many
lordship.
documents.
No, bunch of documents. My lord, there are at least 50 invoices. There are at least 50 invoices. Of those, my lord, 3, my lord, I am producing because, my lord, my endorsement of, my lord, the payments are endorsed on the back of those invoices, which, my lord, copies of which I have already shared with my learned senior friend. But, my lord, the admission of denial, my lord, I'll at least have to take, my lord, 2 days. And in the meantime, my lord, let them share their suggested issues. I've shared my suggested issues. My lord, in that situation, my lord, my lord, I have my copy as well. May I at least go through this?
And what about their admission and denial?
Because
Will
they,
not file.
I no, the same the 3
Well, it's
documents
not-
which they have relied.
No.
That-
With regard to C.
It's admitted. We are disclosing those documents also. We are relying on
The
yes.
common
Common document. Yes.
They're not common documents. I'll tell you, lordship, why. My lord, because this issue, my lord, arises out of, my lord, goods sold and delivered. Now, my lord, invoices were raised on me. My lord, they have the counterparts. Now, my lord, on the originals of some of those invoices, my lord, the receipt of, my lord, acknowledgement of payments were made. So, my lord, I have the originals, they have the counterparts. So, my lord, they may be identical, but they are not the same documents. So, you lordship would see they still have to file it.
Complete both of you fine. You also filed.
They still have to, my lord.
Send the suggested
My lord,
issues.
the suggested issues, my lord, I have.
Yes.
Thank you.
Sons appearing for the plaintiff, sons appearing for the defendant. Where is the suggested issues? You're not.
Yeah,
filed?
I've given him a copy. Yes.
Where is?
Yes.
You will not give to the court. Both the parties have filed their suggested issues. Let the same be kept with the record. Counsel for the respective parties prays for time to file F. Affidavit of admission and denial of the document. Let affidavit of admission and denial be document while within 2 weeks, 1 week.
I'll file within 1 week.
1 week.
Within 1 week. List the matter on KRISHNA. 6th of March for framing of issues.
Grateful, my lord.
Next.
My lord, let them also file an affidavit or document. They are
That's
not
right,
filed.
both,
Yes.
both
Otherwise, we'll don't
both
know what that.
parties.
Yes.
No, because, my lord, what had happened on the last occasion, my lord, they wanted us to, supply the documents so that the judge's brief could be comprehensive. We've done that.
File it, file it.
Ota diye do, ota diye do.
Item number? To be mentioned. Why it is to be mentioned today? He was, Mr. Gomes was here, but he left. He was present here. Not today. Not today.
Lordship, my learned senior Debojyoti Basu is appearing in the another court, Lordship. Came for not today.
What is the correction?
Lordship, I do not have any instruction over this matter, Lordship.
Not today. Item number 3. Not today. Item number 10. What about?
Lord, I appear for the executor.
Yes. What about 9? Over. Yes, 10.
Yes, 10, my lord, I am appearing for the executor. My lord, Lordship would recall, my lord, this is the issue, my lord, between two brothers. My lord, as far as the application which is appearing in your Lordship's list, that is GA1, has been filed by, my lord, one of the heirs of the deceased for removal of the executor. My lord, last occasion, my lord, that is on 25th of January, my lord, we had handed over 2 checks aggregating to a sum of rupees 30 lakhs. And my lord, Mr. Ghosh had to, my lord, take instructions for verification of the accounts.
Yes.
My lord, that is the, my lord.
Where is Mr. Ghosh? Not today. Come tomorrow.
Very well. My lord, one thing, my lord, I don't know, my lord, whether I am correct or not. My lord, this is a testamentary and intestate jurisdiction matter, my lord.
Yes. It has been come as a TS. Converted into TS.
No, it has probate has been granted. Probate has been granted.
Probate is granted in PLA.
In
not
PLA.
TN
Then your
testament.
lordship has the determination.
PLA is here.
Yes.
But testament. Suit gone.
Suit has to go.
Suit has been determination. PLA is still.
PLA is there with your lordship. We'll come tomorrow, my lord.
11.
Item number 11, Lordship, kindly short pass over, Lordship.
Why?
My learned senior is coming, Lordship, on his way, Lordship.
What has happened to the appeal? Who has prepared an appeal?
I have rather my client has preferred the appeal, my lord.
You have
Second-
prepared, yes. Yes.
We preferred an appeal, my lord.
What has happened?
It's still there in the, my lord. I don't know what else to submit to, my lord.
No,
It still hasn't been taken up, my lord. We haven't sought any adjournment. It is just running in the list as item every day. What item is it today? Even today it is there. 22. Every day it is there, my lord. I do not have anything, my lord. Only thing, my lord, the issue here was the lodging of the writ of summons. My lord will recall. That is the reason, that is one of my grounds seeking rejection of plain. That was rejected by my lord. We taken that up in appeal. That is the only issue. My lord has already passed an order of injunction as well, protecting them. I don't think the plaintiff is really aggrieved
If
Achha,
my lord,
the three petition applications.
three applications we had filed, one injunction application, my lord, had disposed of in their favor. They are enjoying an order of injunction today. They are protected. My lord, will kindly then make this, if it commences to, let it go out of list as soon as the appeal court decides.
No.
She's asking for a not today, let her senior come tomorrow, my lord. We'll make these submissions. I am also led by Ms. Suparna Mukherjee, my lord. She'll also.
Yes, Lordship, kindly fix it tomorrow.
My lord, on the last occasion, my
What
lord
is
had
the
fixed a
GFI?
time.
What is the GFI?
J5 is the contentious. That is
G-
the application today after I have taken out my application for rejection of plaint on the ground of Order 7 Rule 9 for non-lodging of written summons.
Lordship, read
After
of
that, they take this out. My lord will only take that into account. So, in fact, this will have a large bearing on my appeal because that is a ground of appeal I've taken. So, my lord, I was only humbly beseeching. Today, they are not suffering any prejudice. Really, they are not also taking any other steps. This is a suit of 2020. They take out this application in
Not today?
2023.
Not today?
Yes, Lordship.
Yes.
I have no.
Or after a week.
No,
Hey,
Lordship,
let
kindly fix it tomorrow.
I
them
have not.
take a chance after a week. I am fixing.
My lord will fix it after.
So suffering for the plaintiff, so suffering for the defendant, counsel for the defendant. Defendant, na? You are for
Defendant,
the
defendant.
For the plaintiff.
Defendants.
Still the appeal is pending. For the interest of justice, okay, they are adjourned for a week. Let the matter appear on.
Not only 4th,
7th
5th, 6th. Yes,
7th March.
7th.
7th March.
Obliged.
12 to 14, my lord. I appear for the plaintiff. My lord, 12 is my application.
My lord, I appear for the defendant number 1, 2, 3.
I appear for the defendant number 4, my lord.
My lord, if your lordship remembers that
Defendant number 5.
Pakistan and
yes,
my lord, GA4 has
Now what
has
will
lost its force, my lord.
So what is to be done now?
GA4 has lost its force because I filed GA6.
No, my lord, it has not lost its force. Because
My lord,
the
I am
amendments
opposing
made
anything
there.
relating to the withdrawal of
Yes.
GA4, my lord.
Yes,
GA4 cannot be
we are
withdrawn.
also opposing. Cannot be withdrawn.
The
My lord, because
Lord, GA4 was my application where I sought deletion of defendant number 6 and 7 because I did not know the heirs of defendant number 6 and 7 and at that particular point of time, and my lord, all the defendants as well as I were in, all of us were interested in denying the interest of the defendant number 6 and 7 in the property, my lord.
Correct.
Now, my lord, subsequent during the pendency, my lord, sometimes in month of September, I came to learn about the names of the widows and the heirs of defendant number 6 and 7. I write letters to them. Your lordship then granted me liberty to take steps. So I have filed GA6.
The GA6.
My lord, GA6 is, my lord, for deletion of name of defendant number 6 and inclusion of his widow and
Recording death.
yes.
When died?
My lord, this was the defendant number 6 had died just few days before the suit was filed.
Okay.
yes.
And my lord, GA's defendant number 7, my lord, died a few days after the suit was filed. We came to know very recent
6 before suit and 7
after
Before
the
suit.
So, my lord, in respect of defendant number 7, I have come to know the names of the widow and the children of defendant number 7.
Take application. And what about the CX? Will file application?
My lord,
we'll file an affidavit, my lord.
My lord will file an affidavit to this because my lord, this has to be dealt with. Because my lord, if somebody has died prior to suit, the suit was itself not maintainable when it was filed. So this error, defect is my lord, inbuilt in the suit. This is incurable. This is incurable.
It's to show that this is not an incurable defect, my
Okay,
lord.
you do one thing, you file affidavit, both the application will be.
Lord, and in the meantime, my prayer is GA6 4 has lost it.
Yes.
4 and 6 will be taken together. If it
Very.
is lost.
No, my lord, we are objecting to that.
My lord,
GA5 is my learned friend's application.
Is my application.
It can wait over till GA4 or 6 is decided.
Which application?
My lord, it is my application for filing my written statement.
Which
There was
application?
GA5,
Right.
my lord.
Let first the suit survive.
Indeed,
Yes,
my
my
lord.
lord.
Indeed,
First the suit survive, then
Indeed.
your application will take on.
Absolutely, my lord.
Students appearing for the plaintiff. Students appearing for the. You are appearing for the defendant number
5.
Mr. Dasgupta.
4. My lord, I'm 4. I'm 4. Defendant number 4. 4.
My lord, I am appearing for
Defendant
defendant
number
number
4.
1, 2, 3.
Mukherjee, learned advocate appearing for Rohit Mukherjee, learned advocate appearing for the defendant 1, 2, 3. Mr. Sen Gupta, learned advocate appearing.
Das Gupta, my lord.
Das Gupta, sorry. Das Gupta, learned advocate appearing for the defendant number 4, and students appearing for the defendant number 5.
5, my lord.
Counsel for the plaintiff has filed an application being GA6 of 2024 and prayed for withdrawal of GA4 of 2020. Counsel for the defendant number 1 to 4 have raised objection for withdrawal of GA4 of 2020. Counsel for the defendant prays for time to file affidavit in opposition in connection with GA6 of 2020. Let affidavit in opposition be filed in respect of GA6 of 2024 within 2 weeks.
My lord would kindly grant 3 weeks, my lord.
My lord, 3 weeks, my lord.
If any.
Lord, your lordship will kindly give me more time because I have 3 affidavits to deal with.
Within 3 weeks thereafter, full stop. Please the matter on 3 weeks, 6 weeks. Na? This the matter on 23rd of April 2024 for hearing of GA6 as well as GA4 of 2020. GA6 of 24 and GA4.
My lord, in the
Kindly
order.
keeps it, kindly keeps it any day after 25th of April, my lord, if my lord. Any day after 25th of April.
Okay, 29th April.
29th. Well,
In the order, my lord has
Grateful, my lord.
defendant numbers 1 to 4 is objecting. My lord, may kindly make it 1 to 5. I am also objecting.
All defendants.
I had
All the appearing defendants.
all defendants number 1 to 5.
Your lordship.
obliged.
Your Lordship, in item number 60, I'm appearing on behalf of the defendant.
Yes. Who is for the plaintiff?
Well, I'm for the plaintiff, my lord. I'm humbly seeking a week's adjournment, my lord.
No, Vesu. What has happened? Documents?
Your Lordship, I have filed the affidavit in documents, praying for leave for filing judge's copy. And
My lord
I
kindly gives us a week's time, my lord.
copy.
Serve the copy?
Yes, serve the copy. Service has been done.
Give that.
My
Yes, what is your...
lord kindly adjourn it for a week, my lord.
For what?
My lord, I'm led by Mr. Shantan Bosch, my lord. My lord, a week time, my lord.
For what, madam?
For my lord, for filing of admission and denial, my lord, and these issues we have not yet exchanged.
And what about the issue, madam? Suggested issues not ready?
Not.
So you are for the plaintiff.
Defendant.
So appearing for the plaintiff. So appearing for the defendant. Counsel for the defendant has filed affidavit of admission and denial.
Denial.
What you filed? Admission of
Affidavit in documents.
affidavit of documents. Get it? Affidavit of documents. After serving the copy to the learned counsel for the plaintiff, let the same be kept with the record. Counsel for the plaintiff prays for time to file affidavit documents. Let affidavit document be filed within a week. Within a week. Full stop. In the meantime, the parties are also directed to exchange the suggested issues. List the matter on 11th March 2024 for framing of issues.
Grateful, my lord. Grateful.
What? Where is your affidavit? Give it. Affirmed. Affirmed. Suggested. 17. Nobody.
Sir, my lord,
No problem, sir. Yes. Yes.
Passover.
You are appearing for? Don't know. On behalf of whom? Not today. Next.
18. Lordship, I am appearing for the plaintiff's lordship. I am appearing for the defendants, madam.
Yes.
We had applied for certified copies of the written statement. We have received it on Well, I Friday, think- your lordship. Keep I it after think- 2 weeks, your lordship. We'll come back with the issues.
For what?
For drawing of issues, your lordship.
Inspection completed?
No, madam.
Not.
No.
Affidavit document filed?
No. Lordship, they were not providing us with the copy of written statement.
No, no,
Lordship.
it's not fair. In fact,
How
my
many
lord,
letters
we
written,
had,
Your Lordship?
we had, my lord, prayed for extension of time. They contested that, and thereafter the written statement was filed. What they have done is this, my lord, they had taken us for a big ride. They are the employees of this TRF. Now, my lord, they filed a criminal case against us for the self-same issue, with that as it may. But the thing is this, my lord, thereafter, they lost in that. FRT was filed. And, my lord, they were given an impression to my clients that we will not proceed with the matter. And that's why, my lord, I did not appear before your lordship because I did not get further instruction.
Your Lordship, the question was of supplying copy of written statement.
Yes. Now,
If
so
they're
far as
filed,
the
provide it.
supplying of the written statement is concerned, my lord, if they send a letter of request to me, I shall obviously comply with that request.
The counsel for the plaintiff submitted, the defendant have not served the copy. Counsel for the submitted, he will apply the certified copy of the written statement in view of the
Your Lordship, we have got that on Friday, Your Lordship.
what certified
Certified copy of the written statement. 5 written statements filed, Your Lordship, by
You
5
got it.
defendants. Yes,
Now,
Your Lordship.
inspection. Now discovery is required.
Yes, Your Lordship.
Sons appearing for the plaintiff. Sons appearing for the defendant. Police to counsel for the defendant submitted. Defendant has obtained the certified copy of the written statement. Statements filed by the defendants. Police. Defendants. The parties are directed to complete the discovery and inspection of the document within 2 weeks. Lordship. Discovery and inspection 2
3 weeks, Your Lordship.
Within 3 weeks.
Basically, my lord, they will be relying upon the code of conduct because we are the employees.
Within 3 weeks. Full stop. In the meantime, the parties are full stop. The parties affidavit of document will be filed within a week thereafter. In the meantime, the parties are also directed to exchange the suggested issues. Full stop. This is the matter on 4th of April 2024 for framing of issues.
Both of them. Well, I'm sorry, my lord. Earlier, I could not appear because I was in absence of the instruction.
In this matter, I appear for the plaintiff, my lord. Just now, I have received a copy. Actually, today is the directed, in the last order on 22nd January, Lordship directed us to complete the inspection and to come back with the suggested issues. But, my lord, we have received a letter from my learned friend requesting to provide further inspection, my lord. So, therefore, the inspection is yet to be completed. We shall provide her the inspection as early as
My lord, I am
possible.
for the defendant bank. My lord, somebody else was, some learned advocate was engaged previously. So this is a change of brief, my lord. So I drop a formal application seeking some time so that we may inspect the documents available and we form the issues, my lord.
Inspection or application for so here.
Sons appearing for the plaintiff, sons appearing for the defendant.
No.
Full stop. Counsel for the plaintiff submitted just 2 days before. Just 2 days before, the plaintiff has received a communication from the counsel for the defendant for disclosure of the document for inspection. So counsel for the defendant submitted. Earlier, some other advocate was engaged by the bank, and now the present advocate has been engaged, and as such, document is required to be inspected afresh. Is required to be inspected afresh and prayed for a direction upon the plaintiff to disclose their document for inspection. Consider the submission made by the counsel for the respective parties. The plaintiff is directed to disclose their document to the defendant for inspection within a week from date. Within a week.
On 4th, 5th, and 6th.
4th, 5th, and 6th of March. We shall.
No, I am only directing you communicate this.
Please to grant, my lord, 2 weeks time.
2 weeks time.
That's it. Within 2 weeks. Full stop. The defendant is also directed to disclose their document to the plaintiff within 2 weeks. Full stop. The parties are directed to complete the inspection of document within 2 weeks thereafter. Full stop. The parties are also directed to file their affidavit of documents within a week thereafter. Okay. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 25th of April 2024 for framing of issues.
My lord, in the meantime, may I be permitted to file the amended copy of the written statement?
It was allowed.
Yes, my lord.
When it was allowed amended?
Leave was granted.
Leave was no
Okay, you take that. Let you come on next.
grateful, your lordship.
Deeply obliged, my lord.
My lord, item 20, my lord, I'm appearing for the plaintiffs, my lord.
Yes.
My lord, this is a very old suit, and parties are the parties are in talking. They are talking for settlement.
How you are telling that the type of for
There are talks of settlement going on, Lordship. Lordship will kindly.
Defendant appear today. Defendant is not there. Plaintiff is appearing. So next time nobody will appear. Then I will because then the party will file an application by this. Let me dismiss this suit. Then
No,
you
Lordship will kindly not dismiss this suit. Kindly not dismiss this suit, my lord. Lordship, all I'm praying for.
I am proceeding with the matter. Once the suit is dismissed, the party is coming. Then the proceeding will be going.
No, my lord, it is not an issue. That is not the issue. Lordship will kindly hear me out, my lord. The erstwhile firm which was handling this matter, that firm is shut. Lordship, the plaintiffs have thereafter they have contacted me, my lord. I have to file my wakalatnama. All I'm asking for is for some time. The parties are already in talks of settlement. Lordship will kindly.
And appears on behalf of the defendant. Then appears on behalf of the defendant. Police of counsel for the plaintiff submits that there a talk of settlement between the parties is going on, and he requests some time. It is fine from the record by an order dated 24 January 2024. This court has directed the parties to complete the discovery and inspection of the document and to file admission and denial and to file affidavit of documents as well as exchange of suggested issues. But till date, the inspection has not been, until date, the order dated 24 January 2024, 4th January 2024 has not been complied with. Considering the submission made by the counsel for the plaintiff as a settlement talk is going on between the parties for the interest of justice, the case is adjourned for 3 weeks. List the matter on 27th of March 2024. In the meantime, if the settlement is arrived between the parties, the parties are directed to file their deed of settlement, or failing which the order dated 24th January 2024 be complied with.
My lord, instead of 27th, may it be on the 1st of April, my lord.
1st of April, then again you will tell something.
No, my lord. No, my lord. We'll come with a settlement. If not, we'll proceed.
For framing of issues.
I'm grateful, my lord. I'm grateful.
Next.
My lord.
Yes.
Item number 1, my lord. I'm very sorry. I was on legs, my lord, when your lordship had called.
No, it is called tomorrow.
I'm ready with my report.
Report.
Yes.
But you have served the copy.
Lord, I'll file to your lordship. I'll serve it, my lord. Then.
You serve the copy?
No, my lord. First, I'll file before your lordship. Once your lordship takes it, my lord, I'll serve it.
Item number 1. What about the remuneration paid?
My lord, 62 has been paid. My lord, the rest have not been paid, my lord.
I will say on that day. You come on that day. Counsel for that Advocate Commissioner appointed by this court is present in person and file the report. Let the same be kept with the record. The commission is directed to circulate the report to the learned advocate appearing for the parties within a week.
Your lordship will discharge me, my lord.
No, I will see on the next. That's why, because all the things is
My
not
lord,
been...
evidence I have already given, my lord. Only the report, my lord, I'll give. My lord, evidence.
Report is not required.
My lord, to the other side, my lord, for circulating. Only the report, my lord. Evidence, all I've served.
Evidence is okay.
Also.
Because I am not discharging, but that remuneration, all the thing is to be seen.
My lord, if they don't want to pay, my lord.
With regard to the clerical charges, secretarial charges, I have passed an order on the last occasion. That's why I'm keeping it. I don't know when the matter is fixed.
Because, my lord, the only thing is, my lord, it's taking a toll on me, my lord. That's...
No, not this. That's... Acha, 17th April.
The only thing is, it's taking a toll on me, my lord. Your lordship is aware, my lord. I will not say much, my lord, what is happening.
No, that's why I'm fixed the 17th April, but 2 hours for cross-examination. I will see how the witness will.
Absolutely, your lordship will see, my lord, and your lordship will understand.
That's why I kept before this court.
I am grateful.
Next.
Lordship, I appear on behalf of the plaintiffs. The last occasion, your lordship had passed an order.
My lord, I appear for the defendant, my lord.
The matter to come up before your lordship on 20th February for framing of issues and hearing out their GA4. Lordship, issues have been exchanged. I have sent my issues. I may be permitted to give.
Item number 21.
Milad 21, Milad GA4 Milad is a restoration application, Milad, which was dismissed for default. Which was dismissed for default on 5th of December 2019. Even within Milad 30 days, Milad, the restoration was filed. Milad, if Milad kindly restores that, Milad, Milad is pending.
What application?
Milad, it's a Milad restoration of Milad variation, vacating application Milad of the interim order. That Milad I am suffering. Restoration of the vacating application which got dismissed for default, Milad, the advocates Milad were on legs at that very moment. If Milad takes Milad page 15, Milad the order will Milad get.
There is no 15,
And
only
Milad
there is no only 13 page in the GA4.
GA4.
GA4 only 13 number page.
Wait, sorry. Milad, it goes on, it's going on with me Milad since last day. I'm saying 15, Milad is saying 13. Sorry, it's 13. Milad kindly says Milad 5th December 2019 order.
Yes.
Milad, only Milad this is for dismissal of Milad that application.
What is
This
that?
is restoration.
What is your application which has been dismissed?
Milad, the vacating application of the interim order that also I have annexed.
You are for the plaintiff. Who is for the plaintiff?
I am for the I appear on behalf of the plaintiff.
I am for the defendant. This is Milad page. If Milad takes page 11.
There are twofold directions. I had given your lordship the issues. Lordship can take this up as well. But I was saying that let the issues be exchanged. Sometime
Yes, Milad.
Lordship, there is subsequent. There is a different proceedings here. Lordship, imagine. Lordship sees the situation scenario. Today was fixed for filing of.
No, that is correct.
I'm not saying. I'm saying yes, kindly. Milad, kindly restores Milad my position, which was there, Milad.
In your issues, that will be taken. What about your GA?
No, I have to make some submission, your lordship.
It within file 30 days. Milad, that is Milad, no section 5, nothing.
Milad,
it was filed immediate.
Yes. Suggestive issue.
Milad, I will bring Milad, if Milad kindly Milad, he restores this Milad, kindly put me back Milad into the position Milad, and Milad is my fault. Milad, which perhaps Milad, I should have come with the issues. Milad, I will take up the issues on my Milad shoulders, Milad, I will do it. But Milad kindly restores this Milad, kindly keeps it Milad any day thereafter. Any day, I'll come back.
So I am fixing both issues and this application because Mr. Datta.
Yes, ma'am.
Your
Yes, ma'am.
what is your submission with restoration?
Milad, the dismissal order is of Milad. Milad, it was filed within 30 days.
Datta is
5th of December 2019 is Milad the order of dismissal.
31 days in December.
Application
within 30 days.
When you filed?
Within Milad on 6th January. If Milad takes 31 days, it's within 30 days. There is no section 5. Otherwise, Milad, there would have been a report to your lordships, Milad, from the department.
For vacating the interim order.
That's what I'm telling. I will take this application
along with the suit.
I will issue will be framed and this will be taken.
Very well.
So well, your issue is not here.
But I'll give the. I was thinking, Milad, that was my wrong understanding, Milad. Wrong understanding on my part. Milad, I was thinking, Milad,
I am fixing the after tomorrow. Come with a suggested
Milad,
issue.
then Milad, it will take some time, Milad. Milad, I was ready with the Milad application to be restored. Milad, kindly then Milad keeps it after 2 weeks, Milad, because Milad
application immediately.
That's what I'm telling.
Milad, kindly then gives me some time, Milad. Kindly don't keep it day after tomorrow.
I'm filing the affidavit of documents.
Counsel for the plaintiff has filed affidavit of document as well as suggested issues. Let the same be kept with the record. Full stop. The Defendant has filed an application being GA 4 of 2020, praying for a restoration, praying for recalling of the order dated
5th December 2019.
Wherein this court has dismissed the GA number 320 of 2019 for default. 20.
It is beyond 30 days.
Default. Full stop. Counsel for the full stop. The counsel for the defendant prays for time to file suggested issues. Full stop. Let the matter appear on.
Give me some time, Millard. Then Millard, if Millard and Millard keeping both the matter together, Millard kindly keeps it after
March.
5th March.
12th
March.
12th March. Very well. But 12th. Millard, it getting dropped, Millard, sometimes. Millard.
Issues as well as here GA 4 of 2020.
Oblige. Oblige. I'll come with the issue. Sir.
এটা তো অফিস